Your Lordship, the court proceedings is muted, Your Lordship.
Court officer, unmute ಮಾಡಿ ದಯವಿಟ್ಟು.
Lordship, lastly, I had tried to move. Lordship had asked me to move it this week. I'm giving my memo.
What stage?
Order. I'm seeking an interim order.
Huh?
I'm seeking an interim order.
For hearing on IA.
Yes.
Please.
Hearing on IA, premature retirement. Since September of last year, this matter is pending, fresh matter.
What happened?
In the memo, date may be given.
Yes.
Serial number 6, you can permit to withdraw.
My lords, may I make one mention, my lords? Item 49. My lords, this was the matter yesterday. My lords were pleased to take up about the scribes and the interim order. My lords, Mr. N.K. Ramesh has been served. And in fact, because it has come in B group and it may or may not reach, can my lords take it up at 2:30? Because he has also received instructions on this. If item number 49, if it can be taken up to at 2:30, my lords, I would be.
But you will have to inform Mr. Ramesh.
I have informed him. I will inform him. I have already informed him in the morning. He is also agreeable. If it can be taken up at 2:30, my lords, he'll be there.
Okay.
Grateful.
Serial number 6. When a counsel for the petitioner has filed a memo dated 10/3/2022, seeking leave of this court to withdraw the writ petition, as the prayer made in the writ petition have become infectious in view of the elections held to the fifth respondent society. So, next para. The memo is taken on record subject to all just exceptions. The petition is accordingly dismissed as withdrawn. Dismissed as having become infectious.
Yes. Much obliged.
With the Lordship's kind leave, my lord. With the Lordship's kind leave, my lord. Serial number 39. Serial number 39.
Adjournments, you please don't mention. Mention only if the other side is here.
My lords, we have informed the other side. We have informed the got their consent as well, my lord.
What is it,
There's
sir?
some
Mysore University guest lecturers. All the other university lecturers, guest lecturers. As per the guidelines of.
Is it a fresh matter?
Exactly.
Is it a fresh matter?
Now, the court has earlier given an election also, even when it is not considered so far. Even government has considered for their lecturers.
Sir, what is it? Is it a new petition, fresh petition? What is it?
It is to be heard.
It
is kept for consideration.
Which year? This writ petition of which year? Writ petition is of which year? What stage is it now?
Decided by that. Fresh matter, old matter. Old matter. Very old matter.
No.
19 matter.
Please give it.
Another is like that. Sorry. Service matter, it is Maharashtra Corporation.
If it is
has been given, it is
if it is in B group, you cannot move.
Any date may be given.
If it is in B group, you cannot move, sir. If it is in final hearing, you file an application for early hearing.
We have filed the application, it is allowed. It was coming before the court.
Then it will come. Then it will come. Yes. You no, let us. You show it to me later. Yes.
My lord, one humble request, my lord, for the one mentioning matter. We have
no adjournments now, sir. Please. If the other side is here, you mention now. Otherwise, you can mention when the matter reaches.
There's some personal inconvenience.
Yes.
About the applicant, petitioner. Petitioner is the wife of the daily wages employee who expired during 2003, my lord. In the process of regularization, my lord. Thereafter, my lord, case was not considered for regularization, my lord. Then, my lord, he is now sought for the pensionary related claim, my lord. made representation to.
Regularization ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ pensionary benefits
ಅಲ್ಲ ಅದು ಮಾಡ್ಬೇಕಂತ. That is our, they have to consider the case for regulation, then they have to give benefit, my lord. That is the case, my lord.
Yes.
That's the government order, my lord.
Then
That-
takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AG.
My lords, I appear for the petitioner in this matter, my lords. My lords,
Yes.
petitioner is working as day group employee in Mysore City Corporation, my lords. She is seeking for regulation of the service.
Which are the other matters that are pending? Which are the other matters
yes.
that are pending?
My lords, there are four matters which are pending, my lords. It is listed on 14th.
ಹೇಳಿ writ petition number ಹೇಳಿ. ಏನ್ರಿ ನೀವು? ಹಾ?
My lords, writ petition number 179. 17903 of 21.
179?
My lords, I apologize. My lords, these matters, my lords, it's Mysore City Corporation matter. This is a case. In rest of the cases, they have regularized on completion of 10 years of service. Here, my lords, they have regularized from 1/8/2006, 6 months after the Umadevi's case. That aspect is challenged, my lords. It's not similar to other cases, but this is there.
Learned AGA takes notice for response number 1 to 3.
1, 2, 3,
And 5.
Yes, ma'am.
And 5. Learned counsel, Srimati Geeta Devi, MP, is directed to take notice for response number 4. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned AGA and learned counsel for response number 4.
Great.
Petition is challenging the annexure A and B on 8 and 9 years. Petition is availed in 2017. Petition availed 10 lakhs per house site, and respondent number 4 and 5 stood as a guarantee. Now the balance is 14 lakh. 14,73,124. Petition is ready to deposit 25% within 4 weeks. Auction is tomorrow.
Learned AGA takes notice for response number 1 and 2. Issue notice to response number 3 to 5. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on learned AGA. Next para. Learned counsel submits that the petitioner has availed housing loan. Correct, Andre?
10 lakh.
Housing loan of rupees 14,73,124.
The balance.
ಇಲ್ರಿ ಹಾಕಿದಾರ 10 lakhs loan ಅಂತ. Second para. 10 rupees 10 lakhs. ಹೌಸಿಂಗ್ ಲೋನ್ ಅಂತಾನು ಹೇಳಿಲ್ಲ ನೀವು.
Purchasing site ಗೆ ತಗೊಂಡು housing loan ಅಂತ ಹೇಳಿ.
While response number 4 and 5 have stood as guarantors. Rupees 10 lakhs from the third respondent, cooperative society, while response number 4 and 5 have stood as guarantors. So, however, since the petitioner was unable to pay the EMI regularly, proceedings were initiated at the hands of the third respondent for recovery of the outstanding loan amount. So, Learned Counsel submits that the second respondent, Assistant Registrar of Cooperative Societies, Mangaluru Subdivision, has passed an award in a sum of rupees. Huh?
The balance is 14 lakhs.
Where do you get that?
Annexure A.
Relay.
14 lakh 73,001 in para.
14 lakh 73,124. And a sale notice has been issued at Annexure B, proposing to conduct the auction on 11/3/2022. So, Learned Counsel submits that the petitioner is ready and willing to pay the entire amount outstanding, if reasonable time is granted. So, consequently, there shall be an ad interim order of stay of all further proceedings consequent to the auction sale notice dated 25/1/2022 at Annexure B. Again, rate to be held on 4/4/2022 ಅಂತ ಬರ್ದಿರಾ?
Mistake. Another amount. On 11,
subject to the petitioner depositing 25% of the award amount within a period of
4 weeks.
4 weeks from today, and an acknowledgement for having deposited the same with the third respondent cooperative bank shall be placed on record, failing which the benefit granted to the petitioner shall stand cancelled automatically. Full stop. Release this matter on 11th of April. Pass over.
May submit. The petitioner is a data entry operator in a panchayat. She was dismissed from service without domestic inquiry, without inquiry. Annexure M is the proceedings of the panchayat at page 45.
Where is your appointment letters?
My lord, she was appointed by a resolution. Annexure A, 5299.
Resolution agalvalla.
She was appointed.
The type of appointment, whether it was a permanent appointment or whether it was a contract appointment.
My lord, she was a
temporary appointment.
She was a temporary appointment. Later, she was after 5299, and she was promoted from bill collector to data entry operator. And as a data entry operator, she was working till 2020. My lord, Annexure M is the proceeding of the panchayat. My lord, CEO at Annexure C has directed the executive.
The original resolution is at Annexure A, is it?
Annexure M.
The original resolution for appointing the
Yes, ma'am.
annexure M.
Annexure A.
Annexure A.
Yes, ma'am.
This is 5/2/1999.
99. As a bill collector. Later, she was promoted as a data entry operator. My lord, when she was a data entry operator, there was a shortage of about 40,000 rupees. And she was the executive CEO, directed the EO at Annexure C, my lord, page 18, directed that the charges shall be framed against the petitioner and another. Charges were not framed. That is a ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ತಯಾರಿಸಿ ಸಲ್ಲಿಸುವಂತೆ ಸೂಚಿಸಿದೆ. This was on 30/7/2019. A show cause notice was issued to the petitioner at Annexure G, page 32. She had shown cause on the next day at Annexure H. Annexure G at page 32 may kindly be seen. Then for this, she has replied at the Annexure H. She has said that she doesn't handle cash. Her work is only data entry. And this explanation is kept pending. Straight away, the proceedings at the Annexure M came to be passed. Page 45. At page 46.
ಕೆಳಗಿನಂತೆ ಲಿಖಿತವಾಗಿ ಒಪ್ಪಿಕೊಂಡಿದ್ದು.
That is
You have admitted.
I have written letter later. My signature was obtained on several blank papers, and that was made use of by the vice president. And the panchayat president was opposed to this. Still, the panchayat passes a resolution, and in fact, there was a direction by the CEO to take action against the PDO and secretary of this particular panchayat, which is found at page 24. They had misutilized the Gram Panchayat funds, page 24, last may kindly see. Line about 7. E kuritante, it says, line about 7. ಈ ಕುರಿತಂತೆ ಈ ಕಚೇರಿಯ ಉಲ್ಲೇಖ 2 ಪತ್ರದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ವರದಿ ಸಲ್ಲಿಸಲು ತಮಗೆ ಸೂಚಿಸಲಾಗಿತ್ತು. ಈ ಕುರಿತು ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ತಾಲೂಕು ಪಂಚಾಯತ್ ಸುಳ್ಯ ಇವರು ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ತಾಲೂಕು ಪಂಚಾಯತ್ ಸುಳ್ಯ ಇವರಿಗೆ ಸಲ್ಲಿಸಿದ ವರದಿಯಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೂ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಕಾರ್ಯದರ್ಶಿಗಳು ಆರ್ಥಿಕ ಶಿಸ್ತು ಪಾಲಿಸಲು ವಿಫಲರಾಗಿದ್ದು ಇದು ಕರ್ತವ್ಯ ಲೋಪವಾಗಿರುತ್ತದೆ. Now kindly turn to the next page. Second paragraph. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮುಖ್ಯ ಲೆಕ್ಕಾಧಿಕಾರಿ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಮಂಗಳೂರು ಇವರು ಸದರಿ 800 ಗ್ರಾಮ ಪಂಚಾಯತ್ ವಿಶೇಷ ಲೆಕ್ಕ ತಪಾಸಣೆ ಕೈಗೊಂಡು ಉಲ್ಲೇಖ 8ರಂತೆ 2017, 16, 17, 18, 19 ಸಾಲಿನ ಲೆಕ್ಕ ತಪಾಸಣಾ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ವರದಿಯಲ್ಲಿ 800 ಗ್ರಾಮ ಪಂಚಾಯತ್ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು ದಾಖಲೆಗಳನ್ನು ತಿರುಚಲಾಗಿದ್ದು ತಿದ್ದುಪಡಿ ಸುಸ್ಥಿತಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲ. ಗಂಭೀರವಾದ ಹಣ ದುರುಪಯೋಗ ಮತ್ತು ಅವ್ಯವಹಾರಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಬಂಧಪಟ್ಟ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ, ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಾರ್ಯದರ್ಶಿ, ಗ್ರಾಮ ಪಂಚಾಯತ್ ಗುಮಾಸ್ತರು ಕಾರಣರಾಗಿದ್ದು ಅವರುಗಳ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ 246 ಅಂತೆ ಆಡಳಿತಾತ್ಮಕ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ ಎಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ.
It includes ಗುಮಾಸ್ತರು also.
ಹೌದು, ನಾನು ಡಾಟಾ ಎಂಟ್ರಿ.
ಅವರು they have given a general description.
ಅಲ್ಲ, ಅದಕ್ಕೆ
anyway it's all right.
Yes,
there was no inquiry conduct.
There was no inquiry at all.
issue notice to the respondent. Next paragraph. Learned counsel for the petitioner submits that the petitioner was appointed as bill collector with the third respondent, Ennur Gram Panchayat, as per resolution dated 5/2/1999, passed by the Gram Panchayat. Stop. Thereafter, she was promoted as data entry operator.
Yes.
During the year?
My lord, that was in the year 2004.
2004. Full stop. However, it was found that there were some irregularities during the year 2016-17 to 2018-19, and there was misappropriation of funds from the account of the Gram Panchayat. Stop. The chief accounts officer of the Jilla Panchayat had conducted an inquiry and found that the Panchayat development officer, the Panchayat secretary, and
Clerk, Gram Panchayat Gumasta.
the other officials of the Gram Panchayat were responsible for the misappropriation of funds, and therefore opined that action was required to be taken against all such persons. Full stop. The chief executive officer of the Jilla Panchayat, Dakshin Kannada, wrote to the executive officer of the Taluk Panchayat, Sulya, to issue charge memo to all the delinquent officers of the Gram Panchayat. So, accordingly, on 18/6/2019, at Annexure G, charge memo was issued to the petitioner along with one Mohan B, who was a bill collector. Stop. The petitioner caused a reply to the said charge memo stating that she was only a data entry operator and she does not handle the funds of the Gram Panchayat, and denied the allegations made against the petitioner. Stop. Learned counsel submits that without holding an inquiry, and on the premise that the petitioner, along with the other delinquent officers, had given a written submission having accepted the charge against them, a decision was taken by the Gram Panchayat as per the impugned resolution dated 21/2020 at annexure M. Dismissing the petitioner from service. Stop. ಇದು ಬಹಳ ಹಳೇದಾಯ್ತಲ್ಲ 21/2020.
Later, that was taken in appeal to the Jilla Panchayat, the CEO. At annexure P is the order affirming the decision of the Panchayat.
Being aggrieved, the petitioner approached the chief executive officer of the Jilla Panchayat. Under section 113(4) of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. Stop. However, the chief executive officer declined to interfere, in terms of the order dated
1/12/2021.
Stop. Next para. But you have not been working. You have not been working from 21/2020.
No, I am not working.
Then what is the interim prayer that you are asking for?
In order that may not be, I am not working. Emergent notice with the direction for them to appear. Because this honorable court in several decisions are held without inquiry.
Nevertheless, when the petitioner admits that she has not been working from the date when the resolution was passed by the Gram Panchayat, no useful purpose would be served if there is an order of stay passed against the order of the chief executive officer. Full stop. Consequently, issue emergent notice to the respondent, returnable by 28th of March 2022. First sentence.
For hand delivery on respondent number 2 and 3, madam.
The petitioner is also permitted to take out hand summons
on respondent number 2 and 3.
Response number 2 and 3.
Government may be directed for respondent number 1. Chief executive.
Illa our person. On 3/3/2022, the following order was passed. Extract from it. Next para. Matters called out. There is no representation for the petitioner. Full stop. Consequently, the writ petition stands dismissed.
Presenting respondent for deletion of respondent number 5 and 8. The selection matter is not. It is number 5 and 8. Is not reported to me.
Where is the memo?
ಅದ್ರ ಮೇಲೆ ಪುಟಪ್ಪ
My lord. My lord, serial number 10 now.
We are at serial number 8.
Oh,
Learned AGA takes notice for response number 1 and 2. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures from the learned AGA. Next para. The learned counsel for petitioner has filed a memo dated 13/11/2017 seeking deletion of response number 5 and 8 from the array of respondents on the ground that challenge was raised in this writ petition to notification dated 21/3/2016, whereby the private respondents were appointed as
a
first division assistants. Stop. However, response number 5 and 8 have not received notice until Allah.
Maybe deleted.
Allah. Now you said that they have not joined.
Not received that.
Huh?
Receive ಮಾಡಲಿಲ್ಲ ಅವರು ಅದಕ್ಕೆ this question of the appointment of the what happened, the petitioner is up. They made application for that attended post, my lord. It is the this is FTC, my lord, is not necessary for.
The challenge was raised in this writ petition to notification dated 21/3/2016, whereby the private respondents were appointed as a first division assistant. However, respondent number 5 and 8
have declined to receive the notice sent by this court. So, it is further stated that the petitioner gives up the claim against respondent number 5 and 8, and therefore they may be deleted from the array. Stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. At the risk of the petitioner, respondents number 5 and 8 are permitted to be deleted from the cost item. Full stop. Learned counsel may carry out the amendment in the cost item. Yes. Within a period of 1 week from today.
Respondent number 4, my lord. Respondent filed objection. If 3 days is granted, I'll comply with the office objection.
Learned counsel for respondent number 4 submits that. What is the objection?
Statement of objection. It is not identified. And the copy has to be served.
The office objections raised on the statement of objections filed at the hands of respondent number 4 shall be complied within a period of 1 week from today. So, a copy of the statement of objections have been served on the learned counsel for petitioner.
Sir,
yes. Ordered accordingly.
Petitioner, my lord. Withdraw this case.
Then a counsel for the petitioner has filed a memo dated 9/3/2022 seeking leave of this court to withdraw the writ petition. Full stop. The memo is taken on record subject to all just exceptions. Full stop. Next para. Accordingly, the writ petition stands dismissed as withdrawn.
Yeah, for the petitioners. I filed 2 applications, my lordship. One for direction and another for I have filed an application for production of additional documents, my lordship.
What are the objections raised?
If copy is not served upon the respondent, lordship, I have served.
You have served.
Well,
Should copy.
Then a counsel for
in this case, my lordship.
response number 5 and 6
5 and 6.
submits that he has received copies of IA number 1 and 3 of 2022.
In this case, my lordship, I am seeking direction to release, to take further necessary steps pursuant to the order passed by the first respondent for releasing the pensionary benefits payable to the petitioner, my lordship. The petitioner was appointed as a FDA under the 5th respondent management, my lordship. While he was in service, on last date of working, my lordship, he was kept under suspension on false charges. Thereafter, my lordship, the charge sheet has been issued by the 5th respondent. The inquiry was conducted. The penalty order was also passed. Against the penalty order, I approached the first respondent, wherein the first respondent has set aside the impugned order of penalty and thereafter directed the respondent to take necessary action to release and pay the pensionary benefits to the petition. In the meanwhile, my lordship, without complying such directions, the 5th respondent again initiated one more inquiry to hold the inquiry on the same set of charges. Against that, my lordship, I have approached the court to challenge the said inquiry is initiated in the law. Therefore, I have approached the revisional authority, wherein the revisional authority has passed an order, which I have produced along with my application, my lordship. During the subsistence of the pendency of the revisional petition, my lordship, the 5th respondent issued one more charge sheet on same set of charges, within the 3rd inquiry on the same set of allegations, my lordship. The 3rd inquiry was stayed by the revision authority, wherein thereafter, my lordship, after considering all the facts, my lordship, the 3rd respondent, the first respondent passed an order. I draw your kind attention to see the annexure, or my lordship, I have produced along with the annexure application for production of document, my lordship. Annexure or, my lordship, the order dated 12th November 2021, passed by the first respondent. I draw your kind attention the relevant portion of the order, my lordship, that page from 9. When the second para, my lordship. When the present petition was pending for consideration before this authority, 2 developments have been taken place having bearing on present petition. The first one is issuance of show cause notice along with the charge sheet to the petitioner on 13 May 2021 under Rule 38-4 of Karnataka Education Institute, Collegiate Education Rules 2003, which has been issued with an intention to hold a fresh inquiry by citing the procedural lapse pointed out by the letter dated 11/2/2019 in conducting inquiry. Further, on behalf of the first respondent, a memo has been filed before his authority on 6/8/2021, submitting issuance of show cause notice dated 6/8/2021 and also bearing the notice of this authority. The fact that the petitioner has filed writ petition number so and so before this honorable court, bearing Bangalore seeking same relief as sought in the present petition, thereby resulting the constitution of parallel proceedings for same relief, which is held to be not maintained, and hence it is contended that the present petition is liable to be dismissed. This argument cannot be my friend. Before proceeding to merits of the case on hand, it is necessary to examine, especially in view of submission of the first respondent, as to whether the present petition is liable to be dismissed on the grounds of that the petitioner has constituted parallel proceedings by filing writ petition number so and so. Along with the memo of first respondent, a copy of said writ petition is produced, and prayer sought is for direction for respondents therein to sanction, release, and pay the retirement benefits to the petitioner, and order for interest for belated payment of said benefits at the rate of 16% per annum, and direct the respondent to extend the
monthly pension payable to the petitioner forthwith and every month. Per contra, the present petition, the prayer sought is for calling for records pertaining to the impugned show cause notice dated 23/8/2019 issued by the first respondent and consequently set aside the same and consequently issue direction to the respondent to take suitable action to release and pay the retirement benefits payable to the petitioner, such as gratuity, leave encashment, pensionary benefit with interest for belated payment of pensionary benefits at the rate of 18% per annum, and direct the respondent to grant monthly pension payable to the petitioner for. In view of the prayer made in the petition, it is clear that prayer is confined only to release of pensionary benefits.
Next day, what happened?
Thereafter, my lordship, after the discussion, my lordship, this the first respondent, the revision authority, has directed page 14, my lordship.
Setting aside the show cause notice dated 23/8/2019 issued by the first respondent, also a direction to issue is issued
to take action to release without the pensionary benefit of the petitioner by not proceeding with the proceeding.
The show cause notice was the first show cause notice, alva?
Houdu sir.
Adadmele
This is second one. 23/8/2019 is the second enquiry. Page 13, I try to pay attention in the same order. Page 13 from second line. Further, the first respondent has in total issued 3 charge sheets upon the petitioner on same set of charges. Page 13 from second line. Further, the first respondent has in total issued 3 charge sheets upon the petitioner on same set of charges, which is nothing but giving perpetuity to inquiry till the petitioner is penalized, thereby abusing the process of law. This attitude of the vigilance cannot be accepted, as it is more 6 years that inquiry has started and is yet to see light at the end of it. Therefore, my lordship, on the same set of charges, the fifth respondent herein has issued.
Therefore, what has been set aside here is the first
second inquiry. This is the second inquiry.
First one, though, earlier it has been set aside.
Firstly, inquiry is already concluded. The penalty order was passed. Against the penalty order, I approached the revision authority.
Second one.
That penalty order is also set aside by the revision authority. Thereafter, after passing the order by the revision authority, the second respondent.
What do you want to submit?
My lord, there was serious allegation of misappropriation of fund of rupees 10 lakhs.
That has been set aside.
My lord, on merit, the charges were proved against this petitioner. My lord, he approached the secretariat under the before the government of Karnataka. Yes. Only mere on the ground of provision is not correct. Correct section is not quoted.
Correct.
And they have not gone through the inquiry proceedings on merit of the case.
You issued a second charge memo and second show cause notice, correcting the earlier one.
Yes.
That has been challenged by this person again before the authority.
Ground for interference by the authorities only, my lord, whether prior permission is obtained from the Commissioner of Education. That is not at all applicable. It's a wrong order, my lord. They have not gone through on merit of the case. There's prima facie allegation of misappropriation of money when he was collecting money from the students. He has remitted the institution money to his bank account. There are prima facie allegations are there, documentary evidence are proved. Only mere non-quoting of the provision under the Education Act, it was set aside. And direction issued to the institution to follow the procedure by quoting proper section. Therefore, my lord, when the petition is pending before the authority, we have submitted a record to show that we have followed the procedure by quoting correct provision of law. That's but from the beginning, my lord, there was continuous stay. When we have issued a show cause notice, he approached the authority and got stay. My lord,
the order challenge madidira.
Now, my lord, I got certificate copy recently, my lord. That took 1.5 months, 2 months for preparation of certificate copy. Now I got it now. I am challenging because, my lord, there is a perverse order passed by the secretary by influence, my lord, not to initiate any action. That is illegal order, my lord. That is curtail the right of the management. Now, because there is serious allegation, prima facie documentary evidence are there, my lord. My lord, page number 40, may kindly see the.
Sir, how can this prayer be granted?
Ordinarily, when it's petition by not proceeding with any disciplinary proceeding against him.
When the respondents have sought to initiate fresh proceedings against you.
Only quoting a proper provision of law, that's all, my lord.
I have before this honorable court based upon the order passed out by the revision authority on first inquiry. When the first inquiry
Correct.
was,
They've initiated a fresh inquiry.
the fresh inquiry, that is
Appointed
also,
a retired district judge.
that is not permissible, my lordship, because there is no direction to de novo inquiry by the competent authority. On the other hand, they have committed the same error by holding the inquiry under their own rules, not to follow the education enactment rules on the rules framework they're under. Therefore, my lordship, I have approached this honorable court pursuant to the order passed out to the revision authority to sanction and release all the monetary benefits payable for
Even taking note of the further developments, subsequent developments, and the latest order issued by the government, revisional authority, they are entitled to challenge that one.
Yes,
They may challenge, my lordship. It is,
How can a direction?
but that order was passed in that order was passed in November, my lordship, November 2021. Till today, they never made any effort to challenge that order. But in the meanwhile, my lordship, I am retired in the year 2015.
That itself is enough to reject your prayer, because they issued a second or initiated a second inquiry, which according to you is not permissible. But right or wrong, they've initiated the inquiry.
That is also set aside.
It has now been set aside. They will challenge it.
Yes, my lord. Now only recently I've got
How
certificate
can
copies.
we direct them to release all the?
Even, my lordship, I have not paid even single provisional pension also, my lordship. Since 2015, my lordship, I have not paid this salary pension. My humble request is, my lordship.
Students in the money collect ಮಾಡಿ ಅವ್ರ ಅಕೌಂಟ್ ಹಾಕೋದಕ್ಕೆ proof ಇದೆ bank
Absolutely, I
account.
have not committed any misconduct as
Sir,
alleged.
that has to be decided finally.
That inquiry was already concluded.
ಅಕೌಂಟ್ ಹಾಕೊಂಡಿದೆ.
Ali charges itself is
Documentary
vague,
proof
my
ಇದೆ.
lordship, because here the first instance they are telling that you have misappropriation 8 lakh. In the charge sheet they have stated that they improved 9 lakh. In the impugned they have stated you have misappropriated 10 lakhs. ಹೀಗೆ.
My lord, from beginning they got stay. ಅವರು secretary without following minimum law.
On 14th of March 2022, learned counsel for the petitioner is required to point out to the provision of law which would enable this court to direct the fifth respondent institution where the petitioner was working and attained the age of superannuation. But since an inquiry was pending, disciplinary inquiry was pending against the petitioner, whether provisional pensionary benefits could be directed to be released to the petitioner, and if so, under what provision? Yes. Monday.
I request for 21st date, please. I will not be in station. Personal inconvenience. 21st, please.
21st.
Come on, 21st.
Yes. Sir Ranjit. On 19/4/2021, the following order was passed. Next para. acknowledgement for having paid the costs of ₹500 as directed, has not been furnished by the petitioner. Full stop. Office objections have not been complied with. Full stop. Consequently, this writ petition stands dismissed for non-compliance of office objections.
I beg to appear for the respondent, fourth respondent. Matter was posted from day before yesterday to today. That this is about these conflicting decisions out of two coordinate benches of this house.
Yes.
I don't know. Whatever I would suggest is, my lord, that this matter requires to be heard by a division bench, because they're conflicting decisions.
Yes, sir. Rajagopal Sahib.
There is no conflict. Conflict is the creation of my learned. Lords, kindly take the interim order granted.
Where are the two decisions?
Two decisions I point. Two decisions. Before I take my lords with two decisions, I have, my lords, at the time of admission, filed a list of authorities before this court. That kindly refer judgment number 1. That is Supreme Court judgment in Pramod versus State of Maharashtra. This judgment has not been referred to by both the learned single judges. However, Lordship Justice Nagaprasanna, in a review application, he referred to this judgment and corrected the error. Interim order has been granted to me, not on the basis of either judgment of one single judge or on the judgment of the other single judge. It has been granted to me on the basis of Supreme Court judgment in Pramod. Now, my lords, may kindly take the judgment in.
What is this issue that has been considered?
Issue is this. Under the UGC regulations, the position is, unless the state government adopts that regulation, retirement age will not get enhanced. It is only recommended. The question here is of an engineering college which is governed by AICTE regulations. Now, from 1st March 2019, AICTE brought into effect the 2019 regulations, under which the regulations themselves, without any discretion of the state government or to any management, enhance the age of retirement for teachers in the engineering colleges governed by AICTE regulations to 65 years. Now, my lords, learned single judge in Professor Datta's case.
Sorry to interrupt, Lord, it is my application for vacating the interim order. There is an interim order that is passed.
No. I asked the learned senior counsel as to what was the law that has been laid down under in what background. So he is only answering to my query.
That he is not arguing. Stay is not even maintainable because interim order was granted after hearing him.
I think.
He started with
no, because you submitted the matter has to be placed before the honorable division bench.
Yes.
I am asking for what is the background.
Ultimately, my lords would agree with him. Even IFR vacating stay has to be considered by division bench.
Yes.
Therefore, that fundamental issue has been raised by him. He should have patience to have that matter settled first. Now, my lords, kindly take this AICTE regulations. Whether they enhance the retirement age automatically.
But even according to you,
yes,
this happened in the year 2019.
Yes, I am. My retirement was due in August 2021.
The decision that you referred to
is
of the year 2016.
Yes, that judgment held. Even under 2010 regulations, the position is it is mandatorily it applies.
Anyway, we are not concerned with this one because now you are saying without any exception, the AICTE has now decided that the age of all the teachers in engineering colleges stands enhanced to 65.
Now
That has happened in the year 2019.
No, I'll further, sir. It has happened in 2010 also, is the view taken by the Supreme Court. And kindly see this, judge, because in the judgment rendered in Professor Dattatreya, this judgment which was available has not been referred at all. Now kindly have a look at this judgment, then whatever my lords would feel. Ultimately, what my learned friend is asking is, this court should refer the matter to division bench to say whether this court should follow Supreme Court judgment or whether this court should follow learned single judgment.
According to him, there are two conflicting decisions.
Conflict had been resolved, this issue was resolved by the Supreme Court even before judgment was rendered by this court in Professor Dattatreya. That has not been brought to the notice of the learned judge who decided Dattatreya. Now kindly have a look at this judgment in Pramod. In Pramod, my lords, the issue was whether retirement age fixed by the state rules made by Maharashtra government would govern, or there is automatic enhancement of retirement age by the AICTE regulations. Supreme Court held that the following of the AICTE regulations regarding the retirement age is mandatory. State rules will have no application. And it is exactly the opposite of that that has been decided in Professor Dattatreya. Kindly take paragraph 2. Paragraph 1. Leave granted. This appeal raises a question of law as to whether, as a senior most lecturer in private polytechnic institution administered by Sri Shivaji Education Society, respondent number 4, the appellant is entitled to consider for appointment to the post of principal because it is required to be made only by promotion by virtue of Rule 3 of the Maharashtra Employees Private Schools Conditions of Service Rules 1981, Brevity MEPS Rule, framed under the Maharashtra Employees of Private Schools Conditions of etc. for Brevity MEPS Act. Then the qualifications and are all discussed. At paragraph 15, at page 511. Paragraph 15, put my lords.
Yes.
On the issue of age of superannuation, there was no occasion for the High Court to consider the relevant rules or notifications, and before us there is a serious controversy as to whether the age of superannuation on the post of a teacher other than principal ought to be 60, 62 or 65. According to the respondent, state government had issued a notification through the Higher Educational Department dated 5/3/2010, whereby the age of superannuation for non-government polytechnic institution has been increased from 58 to 60 years, and it can be extended up to 62 years only after obtaining prior approval of the state government. Similarly, for the post of principal, the age of superannuation has been increased to 65 years, but with the rider that state government will grant approval for any further extension beyond 62 years. On the other hand, this is where AICTE regulations are concerned. On the other hand, the stand of the appellant is that he has been arbitrarily ignored and not considered for extension because of pending litigation against the management of the respondent society since several years. It is a further case of the appellant that state government has never differed with the recommendations of AICTE on the issue of age of superannuation. In exercise of statutory powers under subsection 1 of section 23, read with section 10, 1 and 5 of the All India Council of Technical Education Act 1987, AICTE has issued the regulations dated 5/3/2010, and the regulations inter alia provide for age of superannuation, and since they apply to technical institutions conducting technical education and such other courses, programs and areas as notified by the council from time to time, the age of superannuation for teachers of the polytechnic enhanced to 65 years, with the sole exception of librarian, whose age of superannuation continues to be 62 years. From the materials and rival contentions noted above, it is evident that even as a teacher of the appellant's age of superannuation could have been considered for extension up to 62 years if steps had been taken for the same in due course. That is a position under the 2010 regulation. Then, moreover, the regulations of AICTE being statutory, unless these have been superseded or annulled by a competent authority, the appellant age of superannuation should extended up to 65 years. Lastly, and in any event, this court had directed the maintenance status quo, etc., etc. That is not allowed. As a finding recorded at paragraph 17, that AICTE regulations are mandatory. Therefore, the age of superannuation gets statutorily extended the moment AICTE regulations are made. Now, in the judgment rendered in Professor Dattatreya, this judgment is not noticed. Then what happened in the judgment rendered by Lordship Justice Nagaprasad? Then also initially he did not consider this judgment. Subsequently, in review, that judgment in review also has been placed on record. In that review petition, after considering this judgment, it has been held that this judgment fortifies my stand. Now, whatever be the position.
Where is that order?
My lord, sir, the order in review. Order in review is 30th August 2021. Here, my lords, in this case, the question was the age of retirement under 2019 regulations only. Here, my lords, the other ground is, my lords.
But his lordship has said there is no ground made out for review of the order.
First, what happened was, Lordship Justice Prasanna allowed the writ petition in G.R. Bharat Sai Kumar. That judgment, my lords, I have placed on record and is referred to in the interim order.
Yes.
The my lords may kindly take out that judgment. That is, my lords, along with a memo, it was filed. Report G.R. Sai Kumar. Sorry, my lords, I have marked the citation there.
I just now saw it. You put it in this.
How the next promote admire adane ittiro.
Idrala?
This is the judgment in J.R. Bharat Sai Kumar. This is what has been referred to by this court while granting me interim order. No, my lord, paragraph 2, facts are stated. Petitioner was appointed as lecturer on 1/4/1985. Then, my lord, the institute issued a memo declaring this of would retire in the year 2020. Name of the petitioner in this said memo was at serial number 17 to be retiring on 31/12/2020. That he notices. Thereafter, my lord, para 3, page 4. This court by an order dated 30th December 2020 granted an interim order of stay of retirement to the petitioner, on the strength of which petitioner continues to be in employment in the cadre of professor even as on date. Then interim order's effect is noticed. Now, my lords, paragraph 9 is the question framed. I have given my anxious consideration to the submissions made by the respective learned senior counsel appearing for the petitioner and the fourth respondent institute, the learned counsel appearing for the third respondent AICTE, and the learned additional government advocate appearing for respondent number 1, and have perused the material on record. In furtherance whereof, the point that arises for my consideration is whether the petitioner is entitled to claim that his age of retirement should be 65 years in terms of the regulations of the AICTE. Certain facts are not in dispute. Paragraph 11. Paragraph 10. This college has obtained AICTE approval and then only started its functioning under the AICTE norms. Paragraph 11. AICTE Act was promulgated by the Government of India for a proper planning and coordinated development of technical education system throughout the country, and also to regulate maintenance of norms and standards in technical education and other matters connected therewith. The AICTE came into effect. Act came into effect with effect from 23rd December 1987. Chapter 3 of the Act deals with powers and functions of the Council. Section 10(1) G and I of the Act, which are germane, read as follows. Functions of the Council. It shall be the duty of the Council to take all such steps as it may think fit for ensuring a coordinated and integrated development of technical education and maintenance of standards for the purposes of performing its functions under this Act. G. Evolve suitable performance appraisal systems for technical institutions and universities.
Anyway, the final decision was that the petitioner is entitled.
Yes, and for that, my lord, he refers to the learned judge refers to the judgment in Kailashnath at page 19. Then, my lords, at page 18 about the issuance of the writ petition to private educational institutions, because then, my lords, at page 28 he refers to Krishnamacharya's case, where there is a statutory enforcement to be made. Writ petition would be maintainable. Then, my lord, Jagdish Prasad Sharma, which dealt with the UGC regulations, are distinguished at paragraph 20. Then, my lords, the apex court clearly holds that there is no compulsion to accept the UGC scheme. That finding also has been given. Then at page 34, Unni Krishnan is referred. Then, my lords, there at paragraph 40, Constitution Bench judgment is highlighted and referred. After all this, my lord, he granted relief. Then what happened? A review petition was filed by the management, Siddhganga Institute of Technology, saying that you have not noticed the judgment rendered by Lordship Justice Krishna Kumar. That was rejected by this review petition. And there, while rejecting the review petition, the learned judge refers at paragraph 5 to promote. And after extracting promote in extenso, at page 11, in terms of the law laid down by the apex court in the afore extracted paragraphs, wherein it has been held that the regulations of the AICTE was mandatory to be followed even by a private aided educational institution, private unaided educational institution. The fact therein was also concerning age of retirement, which was from 62 to 65. The apex court has directed for such consideration up to the age of 65 years, and the order was implemented. On this premise, he says that there is no ground to review. And now appeal has been filed against this order. For the last close to 7 months, it is in office objections. And in all similar matters, this honorable court has granted stay. None of them are saying that this is a matter that should go before the division bench. Now, for the division bench, what is the issue that is to be referred?
What is the prayer now in this petition?
In this writ petition, my prayer is that Annexure A notice of retirement should be quashed, where the management proposes to retire me at completion of 60 years, Annexure A at page 13. They wanted to retire me on 31st August 2021. Which is coming into force of the 2019 regulations.
So this is not a continuation of the same. These are different parties and different institutions.
Different institutions, different regulations. Because even in Professor Dattatraya's case, learned judge, while rejecting the claim for enhanced age of retirement, says at paragraph 20, when reference was made to 2019 Handbook of Approvals of AICTE, the my lords could take that judgment in in the statement of objections they have filed at paragraph 160, they are page 162, judgment of Lordship Justice Krishna Kumar. There, at Lord's para 20, page 196. Though it is stated in the aforesaid affidavit by the AICTE as per clause 7.4 of the Approval Process Handbook for 2019-20, there is an obligation cast upon the Care Society and JAT to implement the AICTE regulations. The said clause will come to the aid of the will not come to the aid of the prisoners, since the said clause is prospective. Prospective means what had happened here was, if my lords would see the facts of this case, most of the petitioners, barring one, they are all persons who had retired prior to 1/3/2019. And that is the, and here there is no reference to promote at all in the entire judgment. Now, my lords, on an earlier occasion, this court had a very interesting situation where I was not the advocate, but I was part of the petitioner. In the sense, I was vice chairman of a housing society, which was the aggrieved party there. Mr. C.B. Srinivasan appeared for me in that. A learned judge of this honorable court recorded like this. This is the judgment of the Supreme Court. These are the judgments of our division bench. I am in a confusion as to which should be followed. Therefore, the matter is referred to division bench. The judgment I have placed on record, how the division bench viewed it, that is, my lords, that is ILR 2000. ILR 2008 Karnataka 3603. Paragraph 4 is the order of reference. Being approved by the judgment and decree of the trial court, the appellant filed regular first appeal under section 96 of the CPC. Considering the pecuniary jurisdiction of the appeal filed by the appellant and in the light of section 5 of the Karnataka High Court Act, the matter was posted before the learned single judge on 2023. The learned single judge posted the matter for admission on 21/3. On 21/3, the learned single judge, after hearing the learned counsel for the parties, has referred the matter to the division bench by passing the following order. Sri C.B. Srinivasan, learned counsel appearing for respondent number 2, Housing Society, submits that suit filed by the appellant plaintiff for permanent injunction in respect of the land acquired by respondent 1 BDA was not maintainable in the light of the judgments of this honorable court of the Honorable Supreme Court in Bangalore Development Authority, Lakshmi Chand, and state of Bihar versus Dhirendra Kumar. He further submits that the suit property measuring 2 acres 8 guntha was acquired by respondent number 1 BDA as per Exhibit D to the final notification. The appellant plaintiff relies on division bench judgment of this court in John B. James BDA and another ILR 2000 in support of the maintainability of the suit. As the question of law arises is of some public importance, I deem it appropriate to refer this to a division bench of the court in exercise of powers under section 9.
both parties shall maintain status quo in respect of the suit property. Then, my lords, para 7. After considering the order passed by the Learned Single Judge, we directed both the parties to address their argument in regard to the legality and correctness of the order of reference to the division bench by the Learned Judge. According to us, Section 9 of the Act can be exercised by the Learned Single Judge, provided a case falls within any of the clauses mentioned therein. Section 9 of the Act that is expected, because that gives what are the powers of the single judge is referred there. After extracting that note, paragraph 8 at page 3613.
Let us see what are these.
Section 9, my lord. Section 9, the clauses shown. I will read. Section 9 of the Act reads as under other powers of a single judge. The powers of the High Court in relation to the following matter shall be exercised by a single judge, provided that the judge before whom the matter is posted for hearing may adjourn it for being heard and determined by a bench of 2 judges. Then, determining in which several courts having jurisdiction a suit shall be heard. Admission of appeal in form of operation. Exercise of original jurisdiction and any lot for the time being in force. Appeals under Order 1 243 of the first schedule of the CPC. Appeals in which the subject matter is as to costs only. Any matter of an interlocutory character in appeals and other proceedings. Admission of an appeal presented after the expiry of the period allowed by law of limitation. Exercise of powers conferred by Section 389, 439, etc. Exercise of powers under Section 24 of the CRPC and 4707. Appeals from interlocutory orders where such appeals are allowed by law. Exercise of powers under Clause 1 of Article 226 of the Constitution, except where such power relates to the issue of a writ in the nature of habeas corpus. The present writ petition falls under this category. This writ petition is under Clause 1 of Article 226, and it is not for habeas corpus. Article 227 and 228, Section 10 of the Act reads as follows. Other powers of a bench of 2 judges. That is not relevant for the present case. Para 8. The learned counsel for the appellant was directed to bring to our notice whether any one of the clauses under Section 9 of the Act was attracted in order to refer the matter to division bench by the learned single judge, and also to whether the case in hand can be referred to a division bench in view of Section 5 of the Act. A perusal of the order of the learned single judge discloses that appellant has relied upon judgment of the division bench, wherein it has been held that suit filed the appellant was maintainable. The learned counsel for the second respondent has relied upon 3 judgments of the Supreme Court to show that the suit filed by the plaintiff was not maintainable. When the law is laid down by the Honorable Supreme Court and the facts and circumstances of the present case is fairly covered by the decisions of the Honorable Supreme Court, no High Court can refer the matter to a division bench to decide the question of law. When once an issue is decided by the Supreme Court, judgment of the Honorable Supreme Court is binding on all courts under Article 141 of the Constitution. The learned judge in this case has only stated that appellant's counsel has relied upon the judgment of the division bench of this court. In these circumstances, there was no reason for the learned judge to refer the matter to the division bench in order to decide the question of law, since the Supreme Court has already decided the question of law raised by the parties. In these circumstances, what was open to the learned single judge was either to apply the law raised by the Supreme Court or the law allowed by this court, considering the facts and circumstances of the case. In our view, none of the clauses under Section 9 of the Act has attracted the facts and circumstances of the case. In this case, the question is whether suit filed by the appellant was maintainable or not in view of the acquisition of the land by PDA and allotment of the same to the second respondent. In these circumstances, we are of the opinion that Section 9 of the Act is not applicable to the facts. Therefore, my lord, sir, this applies squarely unless my learned friend is able to find that Pramod is not applicable to MS Ramaya Institute of Technology. Or Pramod is not applicable to my client. Therefore, my lords, this is a matter which my lords will have to hear on merits. Then
they can carry in appeal or I can carry the matter in appeal depending upon what my lords would decide on merits. This is not a case where any reference to the division bench is permissible. In fact, my lords, the Supreme Court also held in K.S. Panduranga's case that where a decision has not been noticed, a binding precedent is not noticed, that is per inquiry. And Lordship Justice Ravindran, in Panchakshari Eligar's case, there is Panchakshari Eligar's case, ILR 1998.
You are referring to that 2019
regulations. Regulations, that is Annexure D.
Annexure D.
How the other one? Okay, I will find out to my lord the position under 2019 regulation. Yes. My lords may kindly turn to page 16. The AICTE regulations.
1st of March 2019.
Yes, it is published by authority in the Gazette Extraordinary dated 1st of March 2019.
Yes.
My lords may kindly turn to clause 1.2.
Yes.
At page 18. Categories of institutions to whom the regulations apply. These shall apply to all degree level technical institutions and universities, including deemed to be universities, imparting technical education and other courses and programs approved by AICTE areas as notified by the council from time to time.
Yes.
Date of effect. Pay scales and DA. The revised pay scale shall be effective from 1/1/2016. Other allowances, my lords, may leave it. Clause 1.4. Effective date of application of the service conditions. All other service conditions, including qualifications, experience, recruitment, promotions, publications, training and course requirements shall come into force with effect from the date of this Gazette notification. To interpret what comes within this clause A, Kailash Nath versus State of Punjab has been relied on by Justice Nath to say conditions of service include retirement age. That has been extracted in Lordship Justice order. That is, it is there then, my lords. This clause 1.4a, it does not leave any choice in anybody. It says it shall come into force on 1/3/2019. Thereafter, my lords, the retirement age is specified at page 22, clause 2.12. The age of superannuation of all faculty members and principals, directors of institutions shall be 65 years. I am a faculty member. An extension of 5 years till the attainment of 60 or 70 years may be given to those faculty members who are physically fit and have written technical books, published papers, and has average 360-degree feedback of more than 8 out of 10, indicating that part of it will not be applicable because I have to retire at the, all that I am saying is that I will retire at the age of 65 years. Then, my lords, what they are relying upon is
this 2000 this notification also has been considered in those judgments.
In Nagaprasanna's judgment, it has been considered. In the Krishna Prasad's judgment, that has not been considered. Just the Lord said, what is the precedent? Judgment is not a precedent if it has not considered the applicable law. And most importantly, it has not considered the Supreme Court judgment which says, what is the difference between UGC regulations and AICTE regulations? One cannot be telescoped into the other. Each will have to be interpreted on its language.
Yes, sir. Yes, sir.
Hello. Main distinction between those cases and our case is, in our case, there are specific rules for informing the age of retirement. Lord, may I take the lordship through that particular order according to me without page one. We have notified our rules. R3 may kindly be seen. R3 at page 64. We have service regulations. The question of service regulations did not arise in case of the other Vishesha technology or Siddhaganga. They had no rules. So therefore, per se, the learned syndicate said, if in the absence of rules, we will apply ACS. But here in our case, the distinguishing factor is that there is a rule pertaining to the age of superannuation. Page 83 may kindly be seen. Specific rule is there. Chapter 11. All employees, you should get it. 83 in my counter. All employees shall retire on attaining age of 58. The board of directors made a discussion, given extension of 1 year or more at a time beyond the superannuation on merits of each case. Lordship gets 83. I'm reading from 83 page in my counter.
Yes.
Chapter 11, 9. The distinguishing feature is this. Second one is allowed. These rules have to be adopted by the government. In fact, kindly have a look at this provision. Regulations. At page commences at page 16. My learned friend read 1.3, page 18. 1.3 my learned friend has read. Pay scale divisions also. Allowance of such LTC special cards so and so. Allowance shall be applicable from the date notified by central government respective state government from time to time. So they have to be notified. Then second, this is all service conditions including qualification, etc. shall come into full effect from date of notification. So that is so far as our kind concerned, there are specific rules in our institution which stipulates. Then Lord, kindly have a look at 21, page 21. 2.11. Financial assistance. Well, I have to make it clear, my lord, but our institution is a private, unaided institution.
Correct.
The central government shall provide by way of assistance 50% of the additional expenditure also on implementing the revised scales of pay, faculty and other staff, such as library, physical, so and so in the state of government, in the state government, government aided, state government autonomous institutions and state university. It doesn't apply to a private, unaided institution. The next pillar, C. The entire liability on account of revision of pay scale with X 1499 shall be taken over by state or so for opting for revision of pay scale. This is in continuation of this. The 2.12 is introduced to say it is 65. Only for private aided, not for private unaided institution. There is no dispute about that fact that I am a private unaided institution. And I have my own rules, unlike in Siddhaganga or in other Visheshwara. So therefore,
clause, clause 1.2.
Yes, Lord.
At page number 18.
Yes, Lord.
Clause 1.2 of the AICTE
yes.
notification.
Approved by AICTE.
Is it not approved by AICTE?
No, these rules
you
are
can't
not
function at all if it is not approved by AICTE.
For other aspects, yes, AICTE, but so far as superannuation is concerned, it is not approved. That is what I am trying to say.
Huh?
No. These rules shall apply to degree level technical education, imparting and such other programs approved by CATC as notified by Hong Kong.
Programs approved, sir.
No, so far as programs and other teaching methodology is concerned. Service conditions.
That is why the learned senior council is submitting that it has been made very clear in Pramod's case that since the rules and regulations formulated by the AICTE is mandatory and applicable to all institutions, all technical institutions. It doesn't make any discretion or differentiation between unaided institution or aided institution or a deemed university or deemed to be university or a regular university.
May I refer
No
to
such-
your concepts in this Justice Krishna Kumar's judgment, which I have produced along with my counter.
Sir, please, go to the decision of the Honorable Supreme Court.
Yes, my lord. Just one applicability. Only one paragraph I would like to read in this Krishna Kumar's judgment. Page 182, my kindly.
Sir, His Lordship has not referred to the decision in Pramod's case. What is the use of going back to that?
Kindly see para 5 what the judge says. Para 5 at page 182. Para 5
yes.
At 182.
Yes.
The AICTE has specifically stated that its regulations governing pay scale will not come into force automatically, and that since management are appointing authorities in the case of unarrangement, the respective managements will have to take a decision by making suitable amendments to respective service reviews. It is also stated that there is an obligation on part of institutions to implement the AICTE regulations, and if they are not implemented, penal consequences follow. So it has to be. In respect to wages superannuation, the matter is at large. In respect to superannuation, the matter is.
Sir, but now, how do you counter the decision of the Honorable Supreme Court in Pramod's case?
All that Supreme Court really did not consider the fact whether there were rules in the institution or not regarding governing superannuation. That is the distinguishing feature. Then para 183 may also be kindly seen. Page 183, para 2. Okay. Internal page 22, 183. The AICTE, which is established under the AICTE Act, has been conferred with the power to make regulations to carry out the purpose of the Act. Pursuant thereto, the AICTE were notified, which provide for applicability of the scheme. As per the said regulations, it was for the respective state governments to adopt and accept the pay scale and its applicability to AICTE approved institutions. In this regard, AICTE has issued notification dated 5/3/2010. I have produced, or I'll make a reference to that. The Gazette notification dated 7/3 issued by the Government of Karnataka in relation to revised pay scale, it was made clear that the scheme shall apply only to teachers, librarians, physical and personal, government aided and university constituent engineering colleges under the control Department of Higher Education. It is contended that the revised pay scale was not applicable to private engineering colleges in the state, including colleges run by KL Society. It is also clear from the aforesaid decision, Government Order 7/3/2011, that the other terms and conditions of service stipulated in the AICTE notification have not been adopted for implementation, even in respect to government controlled institutions to which they apply, and at any rate.
Will you please take me to this notification dated 5/3/2010?
Yes, R4, it's at page 96. R4 is government notification 5/3/2010, page 96. Page 96. 96 is the relevant chart. The entire order 5/3 notification commences at 85, R4. Its relevant is at 96. Item 3. This scheme may be extended to all technical institutions coming under the review of state legislature, provided the state governments wish to adopt and implement the scheme subject to the following terms and conditions. Financial assistance from central government to state government opting to revise pay scale teachers or other equivalent cadre covered by a scheme shall be limited to 80% of the additional expenditure involved in this function. The state government opting for revision of pay shall meet the remaining 20% of the additional expenditure from its own sources. Financial assistance in respect of clause A shall be provided from the period from 1/1/2006 to 31/10/2010. The entire liability on account of revision of pay scale of teachers approved by some shall be taken of the state government. Opting for revision of pay scale reforms also. So government has to make a lot of.
Is there anything in
There is no similar clause in the 2019.
similar clause?
There is no similar clause in 2019 regulations. What my learned friend is referring at page 96. There is no such similar clause in the 2019.
Then can we refer to R6 also? R6 commences at 103. A similar provision is there.
In page number 96, what was pointed out?
That is, my lords, clause 3. The scheme may be extended to all financial institutions coming under the purview of the state legislature, provided state government wish to adopt and implement the scheme subject to the following conditions.
Yes.
There is no such clause in Annexure D.
This was the notification.
Annexure D.
In Pramod's case, this is the notification that was referred to in Pramod's case.
Annexure D complete I have produced from page 16 onwards.
I remember there was one more decision of the Honorable Supreme Court.
Yes.
Very elaborately considering this notification. Because objections were raised by many state governments.
Yes.
I remember very well the state government of West Bengal also had raised objections.
That is, my lords, K. Gopal and others.
K. Gopala.
K. Gopala and others. That was university teachers' pension. My lords allowed my writ petition.
I remember those days when I was a government advocate. Yes. When I was in the first court.
That is not thing, sir. I'll check up and assist my lords.
Then kindly have a look.
I remember there was one.
There was, my lords,
there was one decision of
there is one judgment about the applicability of the ICT regulations in the matter of grant of sanction and all that.
Probably it is the same notification. 2010.
2010.
I fallen for consideration.
I will go through and place it before, because on that I did not. Because today my learned friend was particular about reference to the division bench.
Yes.
My focus was on that. Not that I should not come prepared for other issues.
Yes.
But then, my lords,
R5 may kindly be seen. R5 may also kindly be seen in this connection. Page 101.
The matter, my lords may fix a date and he was on merits.
Yes.
Matter.
ದಯವಿಟ್ಟು ತಾವು ನೋಡಿ, there is a marked difference between this notification of the year 2010 and the 2019 notification. There is no such scope given as was given in the 2010 notification to the state government to adopt the regulation prescribed by the ACTA. 2019 alli that is absent.
And there are half a dozen high court statements, different high courts have placed on record.
They have to look at 2011 notification R5 at page 101. 101 alli enhance the age of superannuation to.
Are they correct? Here there is a scope. There is a scope in the notification itself.
Yes.
Giving discretion to the state governments.
Yes.
But no such discretion is given in the 2019 notification. If it is there, you please point out.
No, this
ಇವಾಗ ನೀವು ಏನು page number 96 ಅಲ್ಲಿ point out ಮಾಡ್ತಾ ಇದ್ದೀರಾ, this kind of a discretion is not given to the state governments in the 2019 notification.
In fact, in the statement of objections filed by ACTC, Lord, they have said that there is no such thing unless the adoption is there.
Allah, our sir. Let us not go to that one because there are decided cases of the Honorable Supreme Court. So we can't go by the stand taken by the ACT.
Lord.
This ನೀವು page number 96 ಅಲ್ಲಿ ಏನು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದೀರಾ, whether this kind of a discretion is available in the 2019 notification is the question.
I'll examine. But anyway, this also may kindly be borne in mind. 101 alli ACTC pay scale ittu antandre in respect to teachers working in government private aided, namdu private unaided. 60 tanka madira 101 alli. That holds the field even now.
Adhe sir, because that there was a discretion given in the notification itself.
Yes.
But that is absent in the 2019 notification.
We'll examine my lord.
What your name got served madilla. Please ask the learned counsel, your learned counsel to serve a copy of the statement of objections on the AICT.
Okay.
Learned counsel for AICT. He says he doesn't have a copy of the objections.
Please, we will today itself we'll have it, sir.
Yes. Third, the learned senior counsel, Shri E.S. Rajgopal, for the petitioner, and learned senior counsel, Shri S.S. Ramadas, for the respondent institution, on the question whether this matter is required to be referred to a larger bench on the ground that there are conflicting decisions of two coordinate benches of this court. Full stop. Next para. Release this matter on yavag martira. When do you want?
17 next week, my lord. 17th, if it is convenient.
17th agboda?
August.
17th of March 2020.
Please.
Yes.
Lords, in this matter, I appear for the petitioners, my lords. I seek for a small passover, my lords. I'm in my links on another court. Serial number 14, my lords. I just seek for a short passover.
Passover.
Lords, like 2:30, my lords, because it is a limited point.
No. 2:30. I've got one more matter.
Very well, my lords. Let it be passed over. I'll just.
Yes.
My lords, I appear for petitioner, my lords. My lords, the office objection, my lord, is about the court fee. I've paid it on 14/2/2022, my lord.
ಇಲ್ಲ ಕೋರ್ಟ್ ಫೀ ಬಗ್ಗೆ ಇಲ್ಲ 5 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ನಾಟ್ ಅಬೌಟ್ ಕೋರ್ಟ್ ಫೀ
And I will comply it, my lord. Meanwhile, notice may be issued. I will definitely comply with the offer.
All right. Learned AGA takes notice for response number
1 to 3, my lords.
1 to 3.
Emergent
ಇಲ್ಲ, ಇದು ಮೂರನೇದು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್. ಇಟ್ಸ್ ಎನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್. I don't know.
Agriculture department, government, my lord.
Department institute ಅಂದ್ರೆ ಆಯ್ತು. Issue notice to respond number 4. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. In the meanwhile, office objections shall be complied with.
Grateful.
Lord, I appear for the petitioners in this matter. Petitioners have sought for mandamus direction, Lord. Only office objection is that, Lord, page number 27, a legible copy is required to be filed at the Kelidare. And the copy is already served on the BPMP, Lord. I have placed material before the court. But I think it is not put up. That's the reason the objection has been raised, saying that the BPMP is not served.
ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ? Learned AGA takes notice for respond number 1. Learned counsel B.V. Muralidhar submits that he has been instructed to appear in this matter on behalf of respond number 2. Full stop. Wakalat shall be filed in the due course.
Lord, the matter pertains to, Lord's equal pay for equal work. Lords, these petitioners, lords, are all employed on temporary basis in the CMCs and TMCs, my lord. Subsequently, my lord, so they said CMCs and TMCs are inserted into BBMP, my lords, in 2008. Their services.
Then you are seeking a mandamus.
Yes, my lord.
To consider your representation.
Yes, my lord. Yes, my lord. Since on par with the other similarly placed employees, claim has been considered at Annexure N, page 81, my lords. Page 81. This Honorable Court, my lords, passed order in 2016 itself on the similar set of circumstances.
This is for regularization.
No, Lord, sir.
That decision is in respect of regularization. You page number 81 alien that is considering Uma Devi's case and direction to consider regularization of services.
Yes, my lord. Yes, my lord.
But you are asking for equal pay for equal work.
Yes, my lord.
That is not considered.
That judgment, my lords, I'll place it before your lordship. On similar set of facts, my lords, I think it is not placed before your lordship, sir. I'll place it, my lords, in 2 days.
But there are the petitioners are all contract employees appointed on consolidated basis. That basis may not be, but annexure K, the representation is given to state government.
State government.
Annexure K.
Otherwise, if you say let it be given to the competent authority, that is the second respondent commissioner, he will consider and pass necessary orders and then he will dispose of the matter.
Yeah, keeping open all contentions.
Please, very well. Very well.
Next para. The petitioners contend that they were initially appointed as civil engineers and assistant engineers at the then Mahadevapura City Municipal Council, as per notification dated 1/3/2004. Stop. During the year 2007, the City Municipal Council, along with other city municipal councils, were merged with the second respondent, BBMP. So, on merger of the municipal councils, the petitioners were working on consolidated pay, and on the roles of the second respondent, BBMP. Stop. The prayer in this petition is to direct the respondents to consider the representations given by the petitioners on 11/8/2021 at Annexure K, seeking equal pay for equal work, single comma, attached to the post in which they are working, and to pass appropriate orders. Stop. Next para. Then a council for the second respondent, BBMP, submits that the petitioners have given their representation to the Principal Secretary, Government of Karnataka, Urban Development Department. And whereas the prayer made by the petitioner is required to be considered by the chief commissioner. Chief commissioner alva ivaga. Chief commissioner, BBMP. So, therefore, the learned counsel submits that if there is a direction to the chief commissioner, BBMP to consider the representations at annexure K, the same will be considered in accordance with law, and orders will be passed. Bada. Let it be the same thing, because they have already come before this court, and we have directed you to take notice. You have a copy of the writ petition along with annexure K. Let the same thing be considered by the commissioner.
Lords, the coordinate bench of this honorable coordinate bench of this honorable court passed order in 5449 of 2015. Order dated 9th February 2018, my lords. That by mistake, my lords, I have placed some other judgment in this. That 5449 of 2015.
If you want to place all those judgments along with your representation,
yes,
we will grant you liberty. You do that and you file a fresh representation.
Already there is a representation mode. Let them consider that, my lords. Otherwise,
if you judgments you don't want to produce that.
No, my lords. I wanted to convey place it before your lordship, sir. Saying
if that is the case,
yes,
this court should consider your claim and pass orders on the merits of the matter.
Please, my lord, please.
Next para. At this stage, the learned counsel for the petitioner submits that there are certain decided cases which would be in the interest of the petitioners. Next para. Having heard the learned counsels, this court is of the considered opinion that the petitioners are required to file a fresh representation to the chief commissioner, BBMP, along with the decisions which the petitioners seek to rely upon. Consequently, this writ petition stands disposed of, reserving such liberty to the petitioners to file a fresh representation to the second respondent, chief commissioner, BBMP, within a period of 15 days.
Please, my lord.
And as and when the representations are given to the chief commissioner, BBMP, he shall consider the same and pass orders in accordance with law, as expeditiously as possible, and at any rate within a period of 2 months. Only for passing orders, 2 months from the date of receipt of the representation. Full stop. Ordered accordingly.
Right.
All contentions we left open.
All contentions are left open.
To pass the similar order. Objection C1 and A23 in the connected matters are no. Same order. So far as in WP 5448, I am withdrawing in so far as
Same order dated 9/3/2022 in 5345 of 2022.
I am filing in memo.
That interim order is only till March.
ಅದರಲ್ಲಿ ಎಲ್ಲದರಲ್ಲಿ ಹಾಗೆ ಇರುತ್ತೆ.
ಅದೇ
Filing a memo in 5-4. So far as the fifth petitioner is concerned, I am drawing.
Learned counsel for the petitioner has filed a memo dated 10/3/2022 stating that the fifth petitioner does not press the writ petition, and therefore the writ petition may be dismissed insofar as petitioner number 5 is concerned. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed insofar as petitioner number 5 is concerned. Full stop. Mikkedalla same.
And deliver. Like, but one more matter. Sorry, that is writ petition. 5375 may also be called along with this. WP 5375/2022.
ಅದು ಮುಂಚೆನೇ ಬಂದಿದೆ.
ಇಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ನಾನು 2 ಸಲ ಮೂವ್ ಮಾಡಿದೆ ಬಂದೇ ಇಲ್ಲ.
ಇವಾಗ ಇಲ್ಲ ಇದೆಲ್ಲ ಆಡ್ ಮಾಡೋದೇನು ಬರುತ್ತೆ?
ಆಡ್ ಮಾಡಿದ ನಾಳೆಗೆ ಇದೆ ಪಿಟಿಷನ್ಸ್ ಎಲ್ಲ.
ಈ ಇದರಲ್ಲಿ ನಾವು ಆದ್ರೆ ಆಡ್ ಮಾಡಿದ್ರೆ ಏನ್ ಪ್ರಯೋಜನ?
Preliminary
it will not be listed again tomorrow. Alva. Please give that number and see that it is listed. Yes. Yes.
Lords, today I had filed an affidavit on behalf of the respondents. In the filing form, I have a copy on the petitioners.
Lord, I appear to the petitioner in this matter. Lord, since 2014, Lord, the petitioner is out of a job. Lord, what I have produced is my services were terminated on the ground that the caste validity certificate was not issued. Lord, later when the matter was taken up in appeal was allowed and the DCVC has now granted the caste verification certificate. I mean this validity certificate. The validity certificate was communicated to them, on the basis of which, Lord, I have sought for a direction to them to quash the order of termination and direct them to reinstate me. That is all. On the last occasion, they raised an objection saying that I did not produce the order copy of the DCVC. Now I have produced the order copy of the appellate authority, order copy of the DCVC, and the letter written by them, saying that since the matter is dismissed for default, we cannot do anything. We have asked for restoration and now the matter is restored. Even according to their letter, not they received the validity certificate. But there is no difficulty in making reinstatement. Kindly look at the documents which I have produced. There is an order by the DCVC dated 23/9/2016, and they have granted me the validity certificate, which has been communicated to them. And Annexure F, as per Annexure F, they say that Annexure F, Annexure G, Malak, they say that you had been dismissed from service so and so. Subsequently, you filed writ petition so and so. The writ petition was dismissed for non-prosecution. As the matter was already in the High Court of Karnataka and dismissed for non-prosecution, we will not be able to act on the letters and proceedings issued by the District Caste Verification Committee.
This order was passed on 4/3/2021.
Yes, brother. This is after remand, Malak. Now, 4/3/21, after passing of this resolution, they sent the validity certificate to the appointing authority. Because it was referred by the appointing authority. And they acknowledge the receipt of this validity certificate. They wrote me a letter as per Annexure G, dated 14th July 2021. I don't think there is any difficulty in directing them to make reinstatement. It's a reserved.
What is the
court.
difficulty? No?
My lord, the counter affidavit that we have filed today, my lord, addresses the specific contentions that are taken by the petitioner, my lord. My lord, the petitioner has been in employment at Oracle India Private Limited after the before the orders were passed by the DCVC. We have made contentions to that effect, and we also intend to produce some case law as to say that there is no automatic right of reinforcement when the organization or the respondent organization does not have the bandwidth and does not have the vacancy to reinstate the petitioner necessarily because the posts and all were filled. Because my lords, because before the DCVC had rejected their application, my lords, and subsequently only it has been allowed after they went to the appellate authority. My lords, we have brought all these facts on record in the affidavit. My only request is it may be adjourned by a week so that the affidavit is also on.
This writ petition was dismissed for non-prosecution.
Yes, madam.
This writ petition was dismissed for non-prosecution in year on 13/12/2017.
For non-furnishing of translated copies, madam. That was
whatever.
preemptive order.
It was dismissed.
Yes, madam.
And now you want to revive this, isn't it?
No, madam, it is restored now.
My lords, it is restored, my lords. It was restored on payment of cost.
So the only reason that you have given in your communication is that this writ petition was already dismissed.
Yes.
Yes,
And therefore we are not able to take any action.
yes, my lord.
And now you are submitting something different.
No, my lords, we have filed an affidavit to that extent, my lord. And we have brought certain facts on record. My only submission is it may be adjourned by a week so that the affidavit can be considered with the application and it can be heard.
At the request of learned counsel for the respondent.
To allow this application, lord, there cannot be any difficulty.
Sir, everything will be heard together and disposed of, sir.
Yes,
ಇದನ್ನ allow ಮಾಡಿ ಮತ್ತೆ ಅದನ್ನ ಕೇಳೋದೇನಿದೆ.
I quite agree with it.
Release this matter on 16th of March.
Yes.
Okay.
Petitioner. Matter, my lord, is on the verge of settlement between the parties. The previous order sheets, my lord, were to be looked into. But we had offered, my lord, a sum of 10 lakhs to the petitioner towards full and final settlement. There is some difference, my lord, which we are rushing out. I request my lords to kindly have this matter on 16th, my lord, by which time we will report settlement.
Learned counsels jointly submit that there is every possibility of amicable settlement of the matter, and therefore the matter may be adjourned. At the request of the learned counsels, release this matter on 16th of March.
Please.
Permitted to appear for Let me 35334 of 2019 is for rate of mandamus. Annexure A, my lord, is a representation where my lord, the petitioner praised my lord, that the authority be directed to consider my lord, about successful completion of probation period.
Since learned counsel, Ms. Sneha Shastri G has entered appearance for the petitioner, the memo of retirement filed at the hands of learned counsel Shri Vigneshwar S. Shastri, senior counsel.
How the
Senior counsel is accepted, and his name is permitted to be removed from the cause list. Yes.
petitioner was appointed as a first division assistant on 15/10/2004. Annexure B is the order. Lordship sees at page 13 Last at page 13 Lordship says. Last paragraph. ಈ ನೇಮಕಾತಿಯು ತಾತ್ಕಾಲಿಕವಾದದ್ದು ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವೆಗಳು ಸಾಮಾನ್ಯ ನೇಮಕಾತಿ 1977 ಪ್ರಕಾರ 2 ವರ್ಷಗಳ ಅರ್ಹತಾ ಪರೀಕ್ಷಣಾ ಅವಧಿಯ ಘೋಷಣೆಗೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಈ ಅವಧಿಯಲ್ಲಿ ಪ್ರಥಮಾದರ್ಜೆ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ನಿಗದಿಪಡಿಸಲಾದ ಎಲ್ಲಾ ಇಲಾಖೆಗಳು ಉತ್ತೀರ್ಣರಾಗಬೇಕು. ತಪ್ಪಿದಲ್ಲಿ ನಾಗರಿಕ ಸೇವಾ ಪರೀಕ್ಷಾರ್ಥ ನಿಯಮ 77ರಂತೆ ಕ್ರಮ ಜರುಗಿಸಲಾಗುವುದು. Now, my lord, as per this, Lord, I took examinations, Lord, annexure C, C1, C2, and C3 are the various departmental examinations, municipal and local bodies, general law part 1, general law part 2, accounts higher, and all examinations were completed successfully by the petitioner. As per annexure C1, Lord, to annexure C3, my lord. Now, my lord, then, my lord, long thereafter, Lord, after a successful completion of the period, I also sought for, Lord, payment of the further increments as per annexure E. That was also granted, Lord. Increment was also granted to me. No, long thereafter, my lord, this is the appointment is 15/10/2004. There was an order of dismissal on 24/5/2017. The dismissal was on the ground, my lord, that the documents given by the petitioner at the stage of entering into the services do not tally with the entries maintained in the the educational institutions, that is pre-university board and the high school records. There is some discrepancy, Lord, as regards the matter. Whatever it is, Lord, there was an order of dismissal, Lord, on 24/5/2017, challenging that, Lord, petitioner filed a petition. Your Lordship sees, Lord, the judgment of this honorable court in annexure C, the connected writ petition, Lord, WP 11322 of 2020, Lord, there, Lord, your Lordship gets that order. Annexure C, Lord, in that writ petition. At page, Lord, 31. Para 2, the petitioner who was selected through the process undertaken by the APSC to fill up SC/ST backlog posts in various departments was appointed as first division assistant in response authority. The appointment was made on 15/4/2004, indicating the probationary period of to be 2 years. The undisputed position is that neither a declaration of the probation has been made nor specific orders have been passed to extend the probationary period. When the petitioner has completed nearly 14 years of service, the impugned order at annexure A dated 24/5/2017 is passed, terminating the petitioner from service. Though it is indicated therein that the petitioner is a probation and is being discharged, hence the petitioner is before this court. The very narration as contained in the order impugned, as also the contentions as urged by the respondents through their objection statement by itself, would indicate that the order cannot be construed as a discharge simpliciter, inasmuch as allegations have been made against the petitioner with regard to the fabrication and manipulation of records for the purpose of obtaining employment, and therefore, in that circumstances, the termination is made. On the legal aspect of the matter, that if an order ostensibly made as an order of discharge of the probationer cause stigma on the person, such an order is liable to be set aside, has been repeatedly enunciated by the Honorable Supreme Court. One such decision to which the learned counsel for the petition makes reference is 99(3) SCC 60.
The respondent is directed to reinstate the petitioner.
Yes, yes. Now, my lord, discipline inquiry, my lord, was pending. It was completed practically, where, my lord, certain documents are not supplied. At that stage, they wanted me to file written arguments. I prayed for documents. They did not supply. Therefore, the connected petition came to file without supplying the documents. They can't proceed with the disciplinary inquiry. They submitted, after
the writ petition is filed. 3 days thereafter, they have submitted the said documents. Now, my lord, so far as this writ petition is concerned, my lord, petitioner has prayed for, my lord, petitioner prays, my lord, that respondent be directed to consider the case of the petitioner, not that she has completed the probationary period. Now, my lord, the relevant rules, my lord, in this regard, my lord, is cadre recruitment rules of PDA, which I have placed, my lord, before the worships. Bangalore Development Authority, Cadre and Recruitment and Conditions of Service Regulations, 1995.
Yes.
Probably not one Xerox. That is sufficient. That is sufficient. Rule 20, Rule 19 and Rule 20, Lord, your Lordship says. Rule 19. Period of probation. All persons appointed by direct recruitment shall be on probation for a period of 2 years, excluding the period, if any, during which the probation was on extraordinary leave. 20. Extension of period of probation. The period of probation may, for reasons to be recorded in writing, be extended by the authority by such period as it deems fit. That is not by the Bangalore Development Authority. 2. By the appointing authority by such period not exceeding half of the prescribed period of probation. That is not 2 plus 1. It is the maximum which the law provides not under this act. If authority is to do it, it has to do by reasons given in writing. Provided that if within the period or extended period of probation, a probationer has appeared for any examinations required to be passed during the period of probation, and the results thereof are not known before the expiry of such period, then the period of probation shall be deemed to have been extended until the publication of results of such examination, or of the first of them in which he fails to pass. So deemed extension is only in a case, my lord, where examination results are withheld or not given, or my lord, a person doesn't passes the examination. Rule 21. Declaration of satisfactory completion of probation period. At the end of the prescribed or extended
What is the prayer in this writ petition?
Please,
what is the prayer in this writ petition?
Prayer, my lord, is to, no, my lord, 17, more than 17 years have lapsed. There is no order, my lord, extending the probationary period. Nor, my lord, probation is declared. I have been continuing service not from the year 2004. There is no complaint not as against me in anything as regards my suitability or the otherwise. I have made a representation annexually requiring the authority, my lord, in the light of these rules, my lord, which provide for confirmation of probationary period, they should consider and pass necessary orders not on the as regards the successful completion of the probation period. Now, in fact, my lord, one of the charge against me, my lord, is at page 40 in the connected writ petition I put is charge sheet. There they say you have not declared yourself successful completion of probationary period. Therefore, you are liable to be removed. Is one charge against me. So it is a duty which they have to do, my lord.
What happened to the inquiry?
My lord, inquiry, they have obtained the stay, my lord, by suppressing the fact. They have received the document. They, my lord, thereafter comes before the court 2 days after, says that we have not furnished the document. They acknowledge the receipt. I produced the acknowledgement.
I think you have ಕೊಟ್ಟಿದ್ರಲ್ಲ documents.
ಕೊಟ್ಟಿದ್ದಾರೆ sir.
Inquiry has to go on.
Inquiry has to go on, my lord. That is, I can't dispute because that is a writ petition. Direction is that. If she is found to be guilty, she is to be removed from service. That is the direction. That is separate.
Then the question of your
what I would
other things will come into the picture.
No,
Not now at this stage.
Now, my lord, what I would respectfully submit, my lord, the two things are different. So far as completion of probation is concerned.
Sir, one of the grounds on which you are sought to be dismissed from service is that you have furnished false certificates.
Correct.
On the basis of that, inquiry is initiated.
I
Only if you succeed,
yes,
the question of your declaration of probation will arise.
No,
not at this stage.
No, my lord, what
not to stay the proceedings and then declare your probation and then permit them to conduct the inquiry.
No, my lord, so far as that aspect is concerned, my lord, I don't dispute before lordships. Lord, 5/10/2020, I have filed WP. They have furnished the records on 7/10/2020. Not, my lord, earlier, whatever it is. Now I have received the document. So continuing the proceedings is not without any difficulty. Now, my lord, that is an independent process where if I found to be my lord, guilty of misconduct.
We will grant you liberty after you are exonerated, and if you are continued in service, you will. They will be definitely. They are required to consider. It is mandated. They will definitely consider your representation for declaration of probation.
I have
all that depends only on the outcome of the disciplinary proceedings.
No, my lord, what I may respectfully submit to your lordship is, I have placed the judgment of the Supreme Court, not along with a list of citation, not a memo of citation, memo of citation, along with the memo of citation, dated 29/1/2021. Court of Saratrai. A 68 Supreme Court, my lord, 1210. There, my lord, the head note, my lord, your lordship says,
yes,
down below, third paragraph, where the service rules fix a certain period of time beyond which the probationary period cannot be extended, and an employee appointed or promoted to a post on probation is allowed to continue in that post after completion of the maximum period of probation without an express order of confirmation. He cannot be deemed to continue in that post as a probationer by implication. The reason is that such an implication is negated by the service rule, forbidding extension of the probationary period beyond the maximum period fixed by it. In such a case, it is permissible to draw the inference that the employee allowed to continue in the post on completion of the maximum period of probation has been confirmed in the post by application. Now here, my lord, 2 + 1 is the maximum period of allowed, my lord, under law.
Sir, you are bound to succeed, but that is possible only after the inquiry is concluded. If you are dismissed from service, where is the question of declaring your probation, sir?
No, my lord, probation they should have under Rule 21, my lord.
You did not ask for it. You did not ask for it at that time.
I did not ask, my lord. In annexure E,
having acquired an order at the hands of this court.
Yes, that is not as regards
the earlier
conducting, my lord, disciplinary proceedings.
And
yes,
there is a specific direction by this court that inquiry has to be conducted, and thereafter whatever has to happen will happen. You can't come before this court and say you stay the inquiry proceedings, declare my probation, and then we'll see. Anta ang madak barodilla.
No, my lord, let the disciplinary inquiry, my lord, continue. That, my lord, on a limited point I came, my lord, for enabling me to.
It will be completed within a period of 2 months. I will direct that.
My lord, what I would respectfully submit, my lord, these probationary rules are something different from the proceedings not related to disciplinary. If I am found to be not have committed wrong, I am liable to be removed. That is where, my lord, I said to say, that's all, my lord.
Purple. The petitioner. So both these petitions are filed at the hands of Srimati H.B. Kamlamma, who is working as a first division assistant with the respondent, Bangalore Development Authority. So, on an earlier occasion, the petitioner was before this court. Calling in WP number 23312 of 2017, calling in question an order of dismissal dated 24/5/2017 passed by the respondent BDA. So this court, by order dated 26/4/2018, held that though the probation of the petitioner was not declared, nevertheless, the petitioner is dismissed from service on the allegation that she had produced fake documents at the time of her appointment. Her appointment, the order of dismissal cannot be held as a discharge simpliciter. Stop. Since stigma is cast against the petitioner, the earlier order of dismissal dated 24/5/2017 was quashed and set aside. Stop. However, liberty was reserved to the respondent to issue appropriate show cause notice, bar charge sheet, bar statement of imputation, provide opportunity to the petitioner in accordance with law, and thereafter proceed further based on such inquiry being held against the petitioner. Stop. It was specifically held that the period presently for which the petitioner was out of employment shall be regulated by the ultimate orders that would be passed, and in that regard, all contentions were left open. Full stop. Next para. Accordingly, charge memo was issued to the petitioner, and disciplinary proceedings were initiated. Stop. However, the petitioner gave a representation dated 12/4/2019 to the commissioner, VDA, seeking declaration of the period of probation in terms of the requirement of law. Stop. Since no orders were passed on the representation given by the petitioner, writ petition number 35334 of 2019 was filed by the petitioner, seeking a direction to the respondent to consider the representation dated 12/4/2019 for confirmation of probationary period to the post and pay all the benefits in accordance with law. Stop. Next para. Nevertheless, on the other side, in the inquiry proceedings, the petitioner contended that she had sought for certain documents and the same were not furnished to her. Stop. Therefore, the second writ petition in WP number 11322 of 2020 was filed by the petitioner.
G and H are the applications they are seeking.
Seeking to quash the entire proceedings, on the ground that the documents sought for by the petitioner were not furnished to her. Full stop. It is not disputed that this court, by an interim order dated 14/10, ಯಾವುದ್ರಲ್ಲಿ
That is in WP 11322.
ಅದು ಅದ್ರಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದು ಕೊಡ್ರಿ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಶೀಟ್ ಇನ್ನೊಂದು ಕೊಡಿ.
11322.
ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು. During the course of the proceedings, disciplinary proceedings, the petitioner made an application dated 29/9/2020 to the inquiry officer seeking certified copies of exhibits P1 to P14, the depositions of PWs 1, 2 and DW1, along with a copy of the oral statement of the delinquent officer, which is recorded by the inquiry officer. Stop. When the same was not provided, the petitioner filed the second writ petition in WP number so and so. Stop. It is not disputed that by an interim order dated 14/10/2020, this court ordered stay of further proceedings in the disciplinary inquiry, till the next date of hearing. Stop. Next para. Learned counsel Sri Balakrishna Shastri, appearing for the petitioner, submits that the grievance of the petitioner relating to the declaration of probation is independent of the disciplinary proceedings initiated against the petitioner, and therefore the learned counsel would pray that the prayer made by the petitioner seeking a direction in the matter of consideration of her representation for declaration of probation should be allowed, while directing the respondent authorities to consider the same and pass orders. Stop. Next para. For contra, learned counsel Sri K. Krishna, appearing for the respondent BDA, submits that when the petitioner has secured an order at the hands of this court in the previous round of litigation, where the order of dismissal which was passed in the year 2017, was quashed and set aside, and with a specific direction, the matter was remanded back to the authority to give an opportunity of hearing to the petitioner and to conduct the disciplinary proceedings in accordance with law, and thereafter pass necessary orders, the petitioner should not be allowed to seek a declaration of her probation when the disciplinary proceedings are underway. So, next para. The learned counsel would further submit that the documents sought for by the petitioner in her application dated so and so.
Sought two times, madam. One was on 14/9/2020. It was given on 23/9/2020. Another one 29/9/2020. It was given on 7/10/2020. After filing? No, before the interview.
Further submits that the petitioner had made two applications, one dated
14/9/2020.
and the other
is 29/9/2020.
So and so, seeking certain documents and information. Full stop. All the documents and information sought by the petitioner has been provided to her, and the same is not disputed by the learned counsel for petitioner. Full stop. Having heard the learned counsels and on perusing the petition papers, this court finds that when this court specifically directed the petitioner specifically directed the respondents to issue appropriate show cause notice, bar charge sheet, bar statement of imputations, provide opportunity to the petitioner in accordance with law, and thereafter proceed further to pass necessary orders. And in the meanwhile, the petitioner was permitted to continue in her services, depending on the ultimate outcome of the disciplinary proceedings, the petitioner cannot be permitted to seek declaration of probation, in the meanwhile. Full stop. Where the very basis for initiating disciplinary proceedings against the petitioner is on the ground that she had produced fake documents while seeking appointment, the petitioner shall not be permitted to seek a declaration of the probation in the meanwhile. Stop. It is obvious that if the finding of the inquiry officer goes against the petitioner that she has furnished fake documents, then everything will come to an end. Full stop. On the other hand, if the petitioner is exonerated of the charges leveled against her, then she is entitled to seek declaration of her probation, in accordance with law. Full stop. Next para. Consequently, both these writ petition stand disposed of with a direction to the respondent authority to conclude the disciplinary proceedings as expeditiously as possible and at any rate within a period of 3 months. From the date of receipt of a copy of this order. Stop. The petitioner is also directed to cooperate in the conclusion of the disciplinary proceedings, which would also be in the interest of the petitioner. Full stop. Ordered accordingly.
This IA number 1 of 2021 has been filed by the petitioner seeking for amendment of the readings and also for incorporating a new prayer. It will be allowed.
Can be allowed. IA number 1 of 2021 is filed against the petitioner seeking amendment of the memorandum of petition. Stop. Then a counsel for the respondent submits that the application can be allowed. Full stop. Consequently, IA number 1 of 2021 is allowed while permitting the petitioner to amend the memorandum of petition in terms of the proposed amendment as found in the application. Full stop. Then at counsel for the petitioner shall carry out the amendment and furnish amended copy of the writ petition within a period of 1 week from today. You want to file additional objections? Next para. Consequently, the respondents are also permitted to file additional objections in view of the amendment brought to the memorandum of petition. Yes.
On the last occasion, asked me to publish the judgment regarding whether the government can withhold the amount or because of financial burden. I'm providing the Supreme Court directly on the point. Paragraph 20 it says that the state government cannot hold. Para 20 last sentence. Para 20 last sentence. The state cannot be allowed to plead financial burden to deny the salary for legally. This is directly on the point your lordship wanted me to file. Though it is well, the government cannot deny the thing. Your lordship, in this case, the petitioners are seeking the revised AICT pay scale. Your lordship was pleased to allow the petition.
And it has been paid to some of them.
Not the other petitioner, all AICT college which comes under AICT thing, everyone is being paid except the College of Pharmacy. For the sole reason, the College of Pharmacy comes under the Health and Family Welfare Department, whereas the technical side, it comes under the Ministry of Higher Education.
That question has been decided and it is held in your favor.
Yes, only because of the technical mistake of impleading the Ministry of Higher Education. My relief, I could not succeed in getting the arrears. Last time they said that there is appeal against your lordship order judgment. It is also a false submission. There is no such appeal. I checked with the status.
No, I have directed you to furnish that information.
Writ appeal against your lordship judgment, they made a false submission. It is not.
False submission. He said her instruction is that it is appeal is preferred. That is why we asked her, if an appeal is preferred, you please give the number. If she has the number, she will give it. Otherwise, she'll say no. ಅಲ್ಲಮ್ಮ ಅದಲ್ಲ. ಹಾ ಆಯ್ತು 230.
Notes, I appear for the respondent corporation, notes. I seek 2 weeks time to file objections, my lords.
Huh?
I appear for the respondent corporation, my lords. I have received the IA, my lords. I'll file objections to the IA and the main petition. A week's time may be granted, my lords.
Lord, the petitioner before the lordship, Lord, is acting as a bill collector. Lord, he is presently, my Lord, an employee of the Tumakuru city municipality. Lord, he was initially appointed, my Lord, on consolidated pay in the year 1994 in the erstwhile Katsandra Mandal Panchayat. Then, my Lord, in the year 1995, I was regularized in the Mandal Panchayat. And subsequently, my Lord, this Mandal Panchayat was merged with the city municipality Tumakuru. Then, in the meanwhile, Lord, there was some issue regarding the fact that whether I was regularly appointed in the Mandal Panchayat or not. Then the Deputy Commissioner Tumakuru conducted a fact-finding inquiry, Lord, and he has recorded a categorical finding that although I was initially appointed on consolidated basis, but subsequently my services were regularized. And consequently, Lord, he passed an order directing that the whole pay and allowance should be paid to me, including the annual increment. But that order I have produced in Annexure A. Subsequently, Lord, a third person, totally, Lord, a person who is not connected to the issue, Lord, he lodges a complaint with the Honorable Lokayukta, complaining that, Lord, I was a consolidated employee, and therefore, Lord, the pay and allowance and the pay scale extended to this petitioner, Lord, is totally.
This matter had earlier come up before me.
Illa tammunde bandilla.
Yes, I heard it.
Yes. Lord, then the Lokayukta conducted an investigation, and Lord, it has sent a recommendation to the state government as per Annexure B, saying that, Lord, whatever amount which was paid to the petitioner as pay and allowance, that should be recovered. That is about 1,50,000. This is, Lord,
why it should be recovered?
It is on the premise that, Lord, my services were not regularized in accordance with law. So therefore, whatever the monetary benefit which is extended to him, Lord, it is not admissible. And therefore, Lord, he recommended to recover the entire amount. This was, Lord, after the Deputy Commissioner records a categorical finding that, Lord, everything is in order. Lord, that order passed by the Deputy Commissioner, Lord, will have some relevance. I have produced, Lord, that Annexure A, which adverts, Lord, to the report submitted by the Deputy Commissioner. Kindly have a look at page 13, Lord.
This is a report under section.
No, my Lord, this is actually
this
is actually an order passed by the Commissioner, by which, my Lord, I was granted.
Annexure B.
Annexure
B.
B, my Lord.
It's a report under section 12(1).
12(1). Lord, after this, here, my Lord, in this report, your Lordship will see the recommendation, my Lord, at page 22, para 10. Then, my Lord, at the bottom of page 23, para 6, the recovery of a sum of rupees 1,50,000 from Shri P. Nagaraj, Bill Collector, CMC, Tumakuru.
You are directed to be removed also. Illa.
Confirmation of the City Municipal Council by the Commission without power or authority. So this is the recommendation. And on this recommendation, Lord, the state government has not proceeded further. And, my Lord, I have been continued in the post of bill collector in the City Municipal Council. However, from March 2020, my Lord, salary is not being paid to me. When I filed an RTI, Lord, I was issued with the communication, my Lord, by the concerned official. Please have a look at, my Lord, page 27, Annexure D.
That is why the Learned Council is saying he wants to file objections.
Now, my Lord, as if this is not sufficient, now, my Lord, a sum of rupees 3,50,000 is sought to be recovered from me, for which, my Lord, I filed this application, and this Honorable Court was kind enough to pass an interim order staying the recovery. Lord, that interim order has already expired on 5th of this month.
So in that background, I have moved this matter.
For a period of 8 weeks ಅಂತ ಹೇಳಿದ್ರು.
ಅದು ಮೊನ್ನೆ 5ನೇ ತಾರೀಕಿಗೆ ಮೂವ್ ಮಾಡಿದೆ. Unfortunately, it is not listed.
At the request of learned counsel for respond number 4, a week's time is granted to file statement of objections to the main matter as well as objections to IA number 2 of 2021. So next para. The interim orders granted on 5/1/2022 shall stand extended until further order.
Great.
Previous occasion, matter came before this honorable court.
Huh?
On previous occasion, my lord, the corporation has stated that other petitions also there. Same issue.
Regularization,
regularization. They have their services have been regularized. But what they have done, my lord, instead of on the completion of 10 years of service, they have regularized on a particular date after 10 years of their service. Now, therefore, they can't get a pension. But in the order, they said they are entitled for pension. And the corporation, in the case of other employees, has regularized their services from expiry of 10 years of service. There is one discrimination.
ಬೇರೆ ಕೇಸ್ಗಳು ಇದಾವಲ್ಲ ಈ ತರದ್ದು.
ಇದರಲ್ಲೇನೆ totally 5 members are before this honorable court. In this petition, 3 members are there. 3 parties. Other 2 persons will have filed a petition in item number 29 in this list. My lord, is the another petitioner. Item number 29.
This matter had come up on 2/3.
And another 3268 of 2022 is the another petitioner. They are all in the same order, include order.
No, why did we adjourn the matter last time?
They have stated that one more petition is there. Some other petition by
City Corporation. There are many cases. There are other cases which, your lordship, this matters. My lord, here, my lord, the petitioners, the government has considered the order which has been specified by the division bench to be the date on which they have to be regularized is 2006.
But I have considered that one.
That is a different batch.
In my decision,
Please, my lord, your lordship's order is in WP 50876 of 2019, wherein your lordship had granted, because the cases were pending consideration at that point of time, my lord, before your lordships. My lord, these petitioners, my lord, there are 2 reasons why the government may not have granted them from the date of the regularization, from the date on which they completed 10 years of service. Because, my lord, some of them are retired, except one person who is still in service, the rest of them are retired from service. The other point, my lord, because the division bench had notified the date. Now, this was adjourned, my lord, because there are other batches of cases with regards to retired employees. So, we need to, my lord, in retired employees, we need to categorize those who are prosecuting the litigation. These are the people who are prosecuting the litigations. There are others who did not prosecute any litigation, who remained silent. And after your lordship's order, they have now filed a case after 10 years of retirement or 8 years retirement. And those matters are pending consideration, which your lordships gave me 2 weeks time to file objections in those matters.
Those are different. If that is the case, my lord, they are different because we are before the honorable court when we are in service, and the directions, the mandamus were given on 3 occasions. Contempt petitions were filed, and in their petition, in writ appeal, the direction was given. Their writ appeals came to dismiss, and this honorable court, well, your lordship, considering the order passed by the division bench, has directed that the services of the even retired employees has to be regularized. And the corporation itself has recommended for 10 years regularization from 10 years. Now they are taking different stand. It is only they are making us to run around pillar to post. Oh, though we have filed a contempt petition, they filed a writ appeal and they unsuccessful. They fought adverse order. We challenged that one. They want to harass us only. That is all. They are now retired. They can't live without pension.
Then what happened before the contempt court?
Contempt petition dropped. You are challenged before the
My
single
lord,
judge.
your lordship's
That is
order was confirmed.
that contempt petition in the earlier round. In the earlier round, the contempt petition was dropped and the endorsement was given. That endorsement was challenged. This honorable court quashed that endorsement and thereafter issued mandamus. After that, the import order has been passed. You are before this court from 1990, my lord. And number of petitions have been filed.
Which is the impugned order?
Impugned order will annexure.
Annexure page 173, my lord.
Annexure B 173.
173.
73. And the order in which the endorsement given by the corporation has been set aside in writ petition number 34996 of 2014, dated 5th February 2020, annexure T.
We will see. We will continue at 2:30.
Please.
Ah.
230 counter is filed.
I had filed the counter in this case.
Reply has to be filed by me. 1 week's time, I will commence the matter. It's a case of.
You want to file a reply?
Yes. This is not the 7th pay commission.
You want to file a rejoinder? At the request of learned senior counsel appearing for the petitioner, a week's time is granted for filing rejoinder to the statement of objections filed at the hands of the respondent state. Yes.
21st.
Release this matter on 21st of March. Yes. No, 2:30.
Sir, court officer serial number 30 ಏನಾದ್ರು adjournment ಆಗಿದೆಯಾ? Serial number 30.
30 ಮಧ್ಯಾಹ್ನ ಸರ್.
ಮಧ್ಯಾಹ್ನ?
ಮಧ್ಯಾಹ್ನ.
ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
Okay, thank you.
Sir, 27 ಇದೆಯಾ?
Court officer. Court officer. Court officer.
Court officer. Court officer. Court officer.
Court officer. Court officer. Court officer. Court officer. Court officer. Sir, Passover matter, will you take it now?
No, madam, after continuation should be asked.
Sorry?
There is a matter to be continued now. After that, it will be continued.
Oh, okay. Thank you.
My Lordship, serial number 30, my Lordship.
Huh?
Serial number 30, my Lordship. A week time may be granted, my Lordship.
Please wait, sir.
Please.
Yes.
49 could be taken.
Huh?
Number 49 could kindly be taken. I mentioned in the morning and requested my boss.
We have got some 230 matters. Please wait. 230 matter will. ಅದಲ್ರಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ 230 ಹೇಳಿದ್ರಿ.
Number 4, Kachina KD.
Yes.
Not a petitioner here is a cooperative society, my lord. The milk producers and the distributors, my lord, in the name of Udugera Milk Production Cooperative Society, my lord. My lord, the respondent number 1 is a CEO of that particular society, my lord. He's been given in charge to execute regarding the particular cooperative society, my lord. My lord, what happens is, my lord, he has caused a misconduct, my lord, and also there is a misappropriation of funds, my lord, and the behavior of him with the other employees is very rude, my lord. And this has been complained with the villagers and agriculturists of the petitioners cooperative society, my lord. Upon the 3 showcase notice has been issued on the respondent number 1, my lord. He has replied, my lord, but those replies are not satisfactory, my lord. Subsequently, my lord, they will have a meeting, my lord, and the resolution is passed that he should be kept under suspension, my lord. My lord, subsequently, that suspension order is being intimated to the respondent number 1, my lord. My lord, may kindly see page number 38, my lord. My lord, this is the suspension order, my lord, which is intimated to the respondent number 1. My lord, what happens in this is, my lord, My lord, it is clearly written in the resolution that he is being suspended, my lord. Whereas in the letter which is intimated, my lord, in the last para, instead of vaja madalagide, instead of writing amanatu, they have written vaja madalagide, my lord. That is a single typographical error which is being made, my lord. My lord, upon this, he'll go file an appeal before the respondent number 2, my lord, that is Assistant Registrar Cooperative Societies, my lord, that without initiating an inquiry, they have passed in suspension order. Sorry, they have dismissed him, my lord. My lord, he subsequently files an IA, my lord, and that IA has been allowed, my lord, saying that his stay should be, that there should be a stay on his dismiss from his post, my lord.
Correct.
Then thereafter, my lord, again agreed by the same, the petitioner approached Karnataka Appellate Tribunal, my lord, but the Appellate Tribunal dismisses, saying that we could have rectified the letter of suspension, that the word suspension would have been changed to the word the word dismiss could have been changed to the suspension, lord. This was the thing, my lord. My lord, we are aggrieved by the same, my lord. My lord,
how are you aggrieved, madam?
My
What
lord,
is wrong in that?
My lord, he has contravened the provisions of the.
That's all right. You were given an opportunity to rectify yourself.
Yes, my lord. My
You
lord,
have not done that.
my lord, meanwhile,
You rectify that, pass a fresh order,
my
and automatically the previous order will go.
My lord, but he has contravened the misconduct conditions, my lord, and also he has caused the grave.
You are unnecessarily wasting your time here. That's all. Would have listened to the directions given by the tribunal. Rectify that order, pass a fresh order. The previous order will go.
My lord, it should also be considered that he has caused a misconduct, my lord.
You want to waste
the
your time here? It is up to you. Issue notice to the respondent. Learned AGA takes notice for respondent number 2. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures from the learned AGA. Yes.
They have filed their objections. In respect to last date of hearing, it was told to them as to whether they are taking notice from numbers 4 to 7. I've served it also on that.
Yes, they were here in the morning. Also, they were here. All right, let us wait for them. Also, let them come.
Very good.
We'll take it. Please wait here. Our career, serial number 49.
We were seeking an interim relief that for the exam starting from Saturday,
Allow
to allow us to bring our own scribes as per the new GO. As per this February 21 GO.
Yes, madam, he is agreeing.
Yes, yes. I'm very happy that he's now agreeing to do it, that an order may be passed. No, I think they must have published it late in the evening yesterday. That is what my friend is telling me. If so, that.
We will record his submission and
yes.
respond. Yes.
Because the GO is at page 48. Page 48. This is a government order dated 11/2.
The petitioners are before this court. Agreed by. Seeking a direction to the third respondent, Karnataka Examination Authority, to follow the provisions contained in the notification dated 26/8/2021.
No, sorry, my lord.
Huh?
There is some confusion. GO, government order dated 11/2/21.
Order dated
11/2/21.
11/2021 at Annexure C.
Yes.
Wherein it is provided that in respect of
My lord's page 49, where page 49, paragraph 6, where candidate can have the discretion of opting for their own scribe.
it is provided that where persons with disability and more particularly persons with benchmark disabilities in category of blindness, locomotor disability, bracketally, both arm affected, -BA, close, and cerebral palsy, facility of scribe shall be given, if so desired by the candidate. So, the petitioners are due to write
The exams for the assistant professor.
the competitive examination for the post of
Assistant professor.
assistant professors, called by, in terms of the notification,
That is 26/8/21 at page 64. 64, 26/8.
no, in terms of the notification dated 26/8/2021. Stop. However, the competitive examination is required to be conducted by the third respondent, Karnataka Examination Authority. Stop.
The issue is that they want to get their own scribes as per clause 6 under the GO. Clause 6.
Next paragraph. Learned senior counsel appearing for the petitioners would submit that although the government order makes provision for appointment of scribe of the choice of the candidate, or they are given a choice to choose a scribe from the panel, which was required to be put in place by the examination authority, the third respondent, Karnataka Examination Authority. Where is that?
My lords, the third respondent at page, my lords, page 183. In fact, they made no mention and they are referring to an old GO, which is 30/10/2007,
Issued
which has been replaced.
A press notification dated 23/2/2022 at Annexure N, stating that provision will be made for providing scribes in terms of the earlier notification dated 30/10/2007.
Yes, which has now been
submitted that the said notification dated 30/10/2007 has been modified, and the latest government order dated
11/2/21.
11/2/21 is holding the field, and provision for use of a scribe was required to be made in terms of the new government order. Full stop. Next para. Learned Counsel Sri N.K. Ramesh, appearing for the third respondent examination authority, submits on instructions that has filed a memo dated 10/3/2022 along with copy of a note dated 9/3/2022 issued by the Executive Director of the Karnataka Examinations Authority. Along with a list of candidates who have sought for scribe facility. So,
sir, new
accordingly,
Ramnagar matter Nayak or Kalika. Sir,
the only all these provisions in this statement are fine, except that they have said that by today 5 o'clock they have to submit the form where I select my own scribe. I only requested my friend, let it be extended to tomorrow, because now the order will be passed. Let it be extended to tomorrow. Till tomorrow 5 p.m. I'll submit this form with the details of the scribe as required, as per the GO. This is as per the GO. Yes, whoever is not.
Andra, what you are saying is there are some columns where it is found no information is given.
Yes.
Only in respect of those candidates.
And
otherwise, other candidates have already.
If they have already submitted, that's well and good. Those who have not submitted, now that he's informing us, till tomorrow the time may be given. We will fill up those annexes.
Executive Director of Karnataka Examination Authority, along with list of candidates who have sought for scribe facility.
Accordingly, the notification has also been put up on the website of the Examinations Authority. Next para. The senior counsel appearing for the petitioner points out from the note dated 9/3/2022 that in respect of those candidates who have not given the details of the scribe as found in the list of candidates, such of the candidates were required to give the information if they intend to
bring their own scribes.
On or before 5 p.m. today. Therefore, the learned senior counsel submits that the time since the notification has been published late in the evening yesterday, the time for giving the information may be extended till 5 p.m. tomorrow.
Let it be at least till 4 or 5. They have to submit photographs of the scribe. Yes, all that we will have to do. No, we are not asking for postponement, but some time should be given. We have filed this petition.
No, but even otherwise, there was no difficulty for these candidates to get the information.
No,
what prevented them to give the information like other?
They were not taking. They were not taking. This was never put up. This has now been put up.
No, this list itself makes it clear that many of you have given the information and they have taken note of that.
Let it be at least till 2 o'clock tomorrow. Let it at least be till 2 p.m. tomorrow.
No, what they are saying is they require some time to verify.
Totally, my lord. There is no difficulty. They all have their own scribe.
You
At
please do
least let it be till tomorrow afternoon at least.
by 12 p.m.
By 12 p.m. Great. 12 p.m. tomorrow, we'll tell them to submit.
12 p.m. tomorrow.
Since notification have been published late in the evening, the time for giving information would be extended till 12 p.m. tomorrow.
Till 5 p.m. That is her submission. Yes. To this, learned counsel, Shri N.K. Ramesh submits that the examinations authority is required to verify the credentials of the scribe, and therefore the time may be extended till 12 p.m. tomorrow. Full stop. Next para. Aye. Okay. Credentials have to be verified. The time should not be extended. Full stop. Next para. Having heard the learned senior counsel for the petitioners and learned counsel Shri N.K. Ramesh for the third respondent, KEA, this court finds that the prayer made by the petitioners have been considered and granted by the third respondent authority. Full stop. However, since the information has been published late in the evening yesterday regarding the information which was required to be given by such of the candidates who intend to make use of their own scribes, the time for giving such information shall stand extended till 12 p.m. tomorrow. That is 11/3/2022. Full stop. Next para.
No, of course. They've already submitted, there is no question of them submitting.
Last comma haಕೊಂಡು in respect of such of the candidates who have already not mentioned the details of the scribe in their application form. Yes. Ordered accordingly. Yes, what is that?
My lords, we just make one more line then. All other provisions of the government order dated 11/2/21 will be followed. My lords may make just one more observation.
Your grievance was only in respect of provision of scribe.
No, my lords. My interim prayer was for scribe, but in my prayer A is that all other provisions of that GO may be followed.
What exactly, madam? You simply can't.
The other provisions, 1 minute, sir. The other provisions are additional time. All that, let them follow.
No,
if they tomorrow don't follow
there
it,
is no grievance regarding that one. They issued a press note in respect of the scribes.
Now they
You are aggrieved of that one.
Yes, but
There's
now
nothing
that
more
they are
to be done.
admitting that this new GO will be in place, all other provisions of that GO should be followed.
Of course, it should be followed.
That may just one line may be mentioned, my lords, because that will make it clear that even they, because nowhere they have mentioned this GO.
There is no grievance made out regarding the other aspects of the notification.
Great respect, I had stated that they had mentioned the old government notification.
That's all right. Your grievance was only in respect of provision of
We
scribes.
issue scribes. As long as they are going to undertake and implement the new GO.
That has been covered, madam. I don't think we should issue such an order. Yes. Learned counsel Shri N.K. Ramesh is permitted to file wakalat. Wakalat within a period of 4 weeks from today.
Great.
Memo file ಮಾಡ್ಬೋದು. ಬಂದಿದ್ದಾರಾ? ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 14 They've
My
not yet
lords,
come.
I appear for my apologies, my lords. Appearing
Yes.
on video conference, my lord.
Ah.
I appear for respondent number 8, the contesting respondent in serial number 14.
Madam, he is there. He has given the. Yes.
Please.
You are the contesting respondent, is it?
No, no, given that. Yes,
No, you are the complainant.
Complainant.
You are
Yes.
the complainant.
Let me take the tomorrow.
That's why it is always better to go on when the matter reaches.
I was on my legs in the other court. That's why I just.
All right. Release this matter tomorrow.
Great.
Number 23.
ಫೈಲ್ ಮಾಡಿದಾರ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದಾರ ಮಾಡಿಲ್ಲ. ಏನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಮ್ಮ? They were already before this court earlier. Huh? $73.
Lordship, one difficulty is there in all the first writ petition. I have quoted in page 19 all the writ petitions AICT which this court had passed order where it was directed 80% should be paid by the central government and 20% by the state government is 20 because here the order is not specific.
No. After this order was passed, they have given the representation. Now it seems now you have given endorsement.
No, if the same order is passed, they will give the same response. And
what response? Where is the response?
That is, I have challenged in Annexure A and B.
Annexure
Annexure. I have to start for challenge of Annexure B and C to be quashed. I have simultaneously challenged 3 other relief before this honor. Annexure B and C and D to be quashed. Your Lordship had asked for the judgment to quash Annexure B and C. I have placed the Supreme Court judgment. So far as quashing Annexure B and
this has been passed after orders were passed by this court, is it?
Yes.
8/5/2019.
Yes, sir. Yes, your Lordship. That is why your Lordship had sought for a judgment. I have given this judgment. Annexure B and C also to be quashed because for financial difficulties they cannot curtail the benefits of the petitioner. I sought 3 prayers. Lordship was pleased to ask me to provide the direct judgment regarding quashing Annexure B and judgment put in.
You please see in page number 88 ಅಲ್ಲಿ ಅದೇ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ 8/5/2019 ಅದ್ರ ಮೇಲ್ಗಡೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿ. ಆಮೇಲೆ ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
Therefore, in this case, many reputations are not get mixed up with the matter. But should kindly have this matter and get reputations have been given the benefits, then this matter.
Madam, if they have been given the benefit, there is no question of giving it once again. Only in respect of those candidates who where the benefit was not granted in terms of the directions given by this court, you are required to give it. You can't give this kind of a reason that there will be additional burden on the. Apply ಮಾಡಿದ್ರೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. There is no question of giving that benefit twice over. You will definitely say it is already given to them, and so therefore in respect of this candidate it's not possible.
Your Lordship, if that was the thing, they could have, they are not mentioned before the contempt court also, that now they are making this kind, because only this professor in page 19.
No, what did you say?
Your Lordship, in page 19, I have quoted all the judgments where this court has passed.
Correct. After these orders were passed, thereafter you filed contempt petition.
Yes.
Why was the contempt proceedings dropped?
Contempt proceedings was dropped because instead of Minister of, mainly because Minister of Health and Family Welfare should be made as a party. Instead, the party was the Ministry, Department of Higher Education. Only for that reason, the court, though one of the division bench held that, okay, it is a sister concern, you can give. But the concerned court found that this error has to be rectified. Only for that reason.
You could have rectified and added the correct respondent.
That is why I am now before this court. I rectified and brought
in our order.
ಅದಕ್ಕೆ ಈಗ ಅದರಲ್ಲಿ since the other two orders B and C were passed, I was constrained to challenge that one also, because that will become an hurdle.
No, it was pointed out before the contempt court that you have taken orders against the respondents who are not the actual persons who are required to give you this benefit.
Yes, sir.
That was pointed out.
That is also been considered in the contempt. And even in their objection, they have said that your Lordship may direct, because since except this petitioners, they have government has given.
Issue to the respondent wherein you consider the claim of the petitioner.
3607.
The paragraph number really. Para 3.
Direction given to issue to the respondent. Direction given to issue to the respondent wherein you consider according to the representation given. Respondent 1, 2, 4, and 3rd July 2018 and 4th July 2018. In fact, the administrative department of the Department of Health and Family Welfare, which was not arrayed as a party, the petition. The State Department has passed an order on 27th
That is annexure T, annexure C. That is the annexure C order.
So in that case, it was complied because it was paid. The delay was because the concerned department was not made a party. Thereafter, they have come to know about this one after the representation was given, and thereafter the amount is paid. So therefore, they said even though there is a delay, they have complied with your orders, and therefore the proceedings are dropped. But what in the respect of the other petitioner? Which is the department which is actually required to pay you the amount?
Ministry of the Health and Family. In fact, in the earlier petition, Drugs Department, which was under the control of Ministry of Health and Welfare Family Department, was actually a party in the petition, which your lordship was pleased to allow the petition. And even the third respondent could have the health drugs controller, who is directly under the control of Ministry of Health and Family Welfare Department, should have mentioned it, because here what
Annexure B, government order dated 8/5/2019, cannot be sustained. It is issued by the Department of Health and Family Welfare. Comply ಮಾಡಿದ್ರೆ ಏನು ತೊಂದರೆ ಇಲ್ಲಮ್ಮ. There cannot be payment once and over again. But this government order will be set aside, and all government orders which are issued similarly will be set aside with a clear direction that this Department of Health and Family Welfare is required to comply with the directions issued earlier, although they were not parties. Now that they have come to know that the direction was actually required to be issued to them, they cannot give a reason that there will be financial burden. Yes, Barkal. Huh? Yes. The petitioners herein.
Lordship, kindly, can I just assist the court? In WP 3607, it has retired professors, whereas in the other, they are working professors. Only those two things I would, so it would be convenient to mention in 3607, all are retired. And in other petitioners, they're all from Government College of Pharmacy.
3607, they are retired.
They're all retired petitioners, retired professors.
Working in various departments.
In same College of Pharmacy.
Pharmacy.
And other petition, they are working lecturers of pharmacy.
The petitioners. That is how it is. That is why they are saying it will be too much of a burden. But then that is between you and the state government. The petitioners in WP number 3607 of 2021 are retired professors
from Government College of Pharmacy,
who are working in a government
College of Pharmacy. And the other,
while the petitioners in the connected writ petition number 3569 of 2021 continue to serve as professors in the Government College of Pharmacy.
Professors, associate professors, they are different.
Professors, bar associate professors.
Faculty, it will be more appropriate to say working faculty.
Professors, bar associate professors, and the teaching staff of the Government College of Pharmacy. So, earlier, these petitioners had approached this court in several repetitions, including WP number 23203-23204 of 2017, 44716 of 2018, and WP number 57575 of 2018. Stop.
Last petition.
Huh? Etc. We
522 of 2019.
And 522
9 of 2019.
9 of 2019. So.
Make a vote of those petition.
The grievance of the writ petitioners in common was that the institutions that they were working in were admitted to grant in aid, and they received the salary grant also. Full stop. But their past services have not been considered. Full stop. In that regard, representations were made, and the same came to be rejected. Full stop. Which is the one where I had passed elaborate orders?
Pertaining to engineering colleges, it is not on record. $55 in WP 360.
WP
3607 ಅಲ್ಲಿ page 50
Case
short order.
61, page 61, 19th March.
It is not disputed at the hands of the respondent state that in all those petitions, directions were issued by this court to the respondent state government
to pay entire amount and recover 80% from the central.
To pay arrears of salary and other emoluments as per the revised pay scale to the petitioners and recover 80% of the same from the government of India in terms of the understanding between the union government and the state government.
As per the revised AICT pay scale.
As per the revised
AICT pay scales.
AICTE pay scales. Stop. Specific directions were issued to consider the representations given by the petitioners and pass appropriate orders within the time frame granted in all those petitions. Full stop. However, learned counsel for the petitioners submits that the state government government orders came to be issued, as seen at annexures B and B1, wherein although the Department of Health and Family Welfare accepted the fact that they were required to pay the arrears of salary in terms of the directions given by this court, however, since the arrears of salary was required to be given from 1/1/2006, it would be a huge financial burden on the state government, and therefore the Department of Health and Family Welfare declined to pay the same to the petitioners. Full stop. Next para. Learned AGA, however, submits that in case of some of the petitioners, the payment has been made by the state government. So, the learned AGA would therefore submit that if the petitioners are permitted to give representation once again, the same will be considered, and the arrears of salary will be paid. So, next para. Having regard to the submissions made by the learned counsel for petitioners, and on going through the impugned government orders, such as the one issued on 8/5/2019 in WP number 3607 of 2021, it is clear that the state government has declined to pay the arrears of salary and other emoluments as per the revised pay scale provided by the AACTE, only on the ground that it would be a huge financial burden on the state government. So, then a counsel for the petitioner has rightly relied upon a decision of the Honorable Supreme Court in the case of North Delhi Municipal Corporation versus Dr. Ram Naresh Sharma and others in civil appeal number 4578 of 2021, dated 3rd of August 2021, wherein it was held that when once the services of the employee is utilized by the state government or its establishments without demur, the state government and its establishments are required to pay their lawful remuneration dash arrears without pleading financial burden and the legitimate salary accrued to the employees cannot be denied on the ground of financial burden on the government. Full stop. Consequently, these petitions stand disposed of with a specific direction to the Department of Health and Family Welfare, Government of Karnataka, to pay the arrears of salary and other emoluments as per the
From 1/1/2006 to
pay scale fixed by the AACTE
from
from 1/1/2006
to 31/10. Even 3/2010.
Where do you get that?
In page 3 in synopsis.
Allah, 31/10/2011. Huh? Please see annexure B, page number 87. SE Nagaraj ಅವ್ರ ವಿಚಾರದಲ್ಲಿ do you get that? Annexure B. Page number 87.
7/5/2000.
Annexure B ಸಿಕ್ತೇನ್ರಿ ನೀವೇ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡೋದ್ರಲ್ಲ ಈಗ Annexure B B1 Annexure B ಫಸ್ಟ್ ಪೇಜ್ ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಡಿ
7/10/2011.
ಕರೆಕ್ಟಾ from 1/1/2006 to 31/10/2011. To such of the petitioners and other similarly situated persons to whom the arrears have not already been paid, as expeditiously as possible and at any rate within a period of 3 months.
It was given 2 months. 3 months.
3 months from the date of receipt of a certified copy of this
2
order.
months. Because they are already 70 years first group, their age.
2 months.
6% interest. Last time this court has given 8% interest. Supreme Court has said 6%. It may be.
ನಿಮ್ಮ representation ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದೇ ತರ ಕೊಡಿ. Yes. Huh? 23 ಹತ್ರ ಮಾಡಿದೀವಿ ಇವಾಗ.
Annexure B and C may be clashed. B, C and D. That's not for.
ಎರಡರಲ್ಲೂ B and B1
B, C and D.
B, C and D ಎರಡರಲ್ಲೂ
ಮೂರು ಅಂದ್ರೆ ಒಂದೇ ಆರ್ಡರ್. B, C ಒಂದೇ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ. D ಇನ್ನೊಂದಲ್ಲಿ ಇದೆ. ಅಂದ್ರೆ 11 month ಇಂದ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Instead of
consequently the impugned government orders dated so and so at annexure so and so are hereby quashed and set aside. In that government order, it is there like that.
Engineering college. Those come to other polytechnics and.
Yes. Yes. 25. Sorry. 25 pass over ಆಗಿದೆಯಾ? ಕರೀರಿ. Yes. You were saying the other matters are listed on. List ಆಗಿದ್ದು 10th ಗೆ. All of them were listed today.
Monday it was listed. Listed. One matter your lordship was listed on 14. The rest of the matters your lordship has given me 2 weeks time to file objections. Based on the cases, I'm making a distinction in these cases, my lord, that they had not challenged any order at all. So after retirement, those people have now filed the case when 68, 70. And so therefore, we are raising the issue of delay and lapses and acquiescence in those batches. So far as these cases are concerned, my lord, the petitioners have been challenging and even before the court, and the writ appeal, in the writ appeal case before the dishonorable court, well, this was before your lordship's order, my lord. Prior to
No, that order of the division bench was also noticed by me in my order.
no, my lord, it was not noticed, my lord.
That order has passed without hearing us. At the notice stage itself, on the ground of delay itself, that has been rejected. Their writ appeal that has been rejected on the ground of delay itself. And that the observation made by the honorable division bench cannot be stated that a ratio decided. There is no application of mind by the respondents to while passing the impugned order. They are not given any reason. That order in writ appeal, my lord, is only after hearing the petitioners.
Where is my order?
Your order, my lord, not produced along with the petition, but I am supplying. Mentioned the case number. Page number. Internal page 9, my lord, pair number 4. Worship has gone to
Which
the
is the division bench order you were pointing out to? Is it in writ number
45 of 2013 that I have
45
produced?
of 2013, my lord.
I have noticed that one in my order. In paragraph number 4, I have noticed that order.
Please, my lord.
The direction is very clear, my lord. Page number 8, internal page number 8.
So having considered that one and holding that they are required to be given that benefit, how can the corporation or the deputy commissioner once again point out to that earlier order of the division bench?
May I just clarify, my lord? The order which is included before your lordship was prior to your lordship's order, which your lordship is now referring to in the writ petition 50876 of 2019. My lord, this order that has been, government has passed the order in annexure V, which is dated October 2020, my lord. September 2020. It was prior to your lord, this lordship's order, my lord. The present order which your lordship is now referring to, my lord.
Annexure?
Annexure V at page 173.
In which there is only one writ petition here, isn't it?
Yes.
WP,
in the include order, referring to the include order.
WP 8331 of 2021, serial number 25, my lord. Serial number 29 was similar, but I'm referring to serial number 25.
Annexure V, page 173.
173. The operative portion comes at 175.
This was a government order dated 11/9/2020.
2020, which is prior to your lordship's order on 21st October 2020, my lord.
So, in the light of the earlier order of mine, we'll have to pass similar orders then.
The government has to pass the order, my lord. In fact, the government has held that this should not be treated as a precedent, and that's why
all the that division bench that has been referred to has been considered by me.
Please, my lord.
And subsequently, I have given directions.
And the lord's order was taken before the division bench, lord. Division bench has dismissed their appeal. Similarly, my lord, holding that it's only a mandamus.
Yes. Then they are entitled for the benefit then.
And in the application, I have produced some documents. And these annexures, my lord, shows that the very same government, my lord, the officer has passed the order regularizing services of my colleagues. From in the application, my lord, on 7th February 2022, I filed the application. My lord, along with I have produced some documents. In that lord, the annexure Y is the order, my lord, the consequent to the order passed by this honorable court, my lord, they have regularized the services of the other employees. from 10 years from the service. Annexure.
That was my order.
The department has passed the order, and in annexure Z, my lord, answer Z, the government has passed the order from the date of 10 years without any direction. These four junior engineers, my lord, in the respondent corporation, they have regular their services in the same officer, this under secretary, has passed the order, though it is subsequently. Now they are not accepting their stand that yeah, I am also entitled for the same benefit. This is the on regarding the discrimination.
This order is passed when?
This order was passed recently on 2/9/2021.
Annexure Y.
Annexure Z. Annexure Z 2/9/2021.
Annexure Y.
Y is dated
2021.
Please.
This is consequent to the orders. Yes.
Yes, please.
WP number 508.
Consequent to your lordship's order, my lord.
And what they have referred is the annexure Z. I have produced along with petition. It is the 24/11/1985 circular issued by the department granting the time scale. We are also sailing with the other parties in the same government circular. And it is mentioned that all service particulars mentioned in that circular has to be followed and has to be considered.
Yes.
Therefore, we cannot make any discrimination.
Yes, madam. I'll proceed to pass orders in this one.
Serial number 29
in this one, there is no difficulty. In respect of the others who had already retired and thereafter they have come, you file your objections. We will see.
Please, my lord.
Anyway, those are not listed today. Those are not listed today.
They are not listed, my lord.
Yes.
They should not be treated as a precedent for those cases. That's my.
In fact, the benefit of that order should have been given to all similarly placed persons. I cannot say much. When an order is passed, taking into consideration similar facts, the benefit should have been given to all similarly placed persons. Anyway, what you have pointed out is this order was passed much prior to the order that I had passed. So therefore, only on that ground, we can say since here it was passed earlier, it requires to be considered and set aside while directing the authorities to reconsider in the light of the earlier decisions of mine.
Very well, my lord.
Yes.
Very well.
Serial number 29, today's list, it is the same case, similar, another petitioner, another party.
Serial number 29. He is also still in service.
He is retired.
They have retired, my lord. He is also retired.
Order. One of the employee in the impugned order.
Alluno, in my earlier order also, there were some petitioners who had already retired.
My lord, I have taken distinguished, my lord. Even retirement, my lord, the issue of retirement, I would not like to raise here, my lord, because the petitioner, when the directions were given, the petitioners were in service. Similarly, your lordship's order also was where they were in service when the writ petition was filed. So at the date of consideration, perhaps they had retired. So therefore, my lord, the retirement, I would say in these cases, because on the date they got the order by this honorable court, and when the government was able to be considered, they were in service.
Yes. So serial number
29.
29. This one is 25. 25 and 29.
Please, my lords.
Yes. Learned counsel for the petitioner. Petitioners submits that the grievance raised by the petitioners herein, who are employees of the respondent, Mysore City Corporation, in the matter of regularization of their services, have been considered and relief has been given to many such employees by this court in WP number 50876 of 2019 and connected matters. However, learned counsel further submits that in WP number 8331 of 2021, the representations given by the petitioners seeking regularization of their services after completion of 10 years of service, in terms of the directions given by the Honorable Supreme Court in the case of Umadevi versus State of Karnataka, in paragraph number 53, was rejected by the impugned government order dated 11/9/2020, and therefore the petitioners are before this court. So, what about the other petition?
Other petition, he is one of the beneficiaries. He is telling the
Same, my lord.
similar
Similar orders passed.
The petitioner, this petition, my lord, serial number 2, 5, and 6 in the import order. Yeah, then another one is serial number 1 in the import order. The same order. So, 6 persons were
common order. ಇಲ್ಲಿ 6 ಜನ ಇದ್ದಾರೆ.
6 ಜನ ಇದ್ದಾರೆ. ಇಲ್ಲಿ one has filed the serial number 29. 2, 5, 6 are the petitioners in this petition.
However, it is submitted that few days after the impugned government order was issued, this court considered similar grievances and decided writ petitions number 50876 of 2019 and connected matters on 21st of October 2020. Stop. The learned counsel therefore prays for similar orders as was granted in WP number 50876 of 2019, while quashing the impugned government order.
So far as insofar as denying the regulation from 10 years, only insofar as entire order, only insofar as order they have regularized my service from a particular date, but the entire order is not challenged. Only regarding the date, my lord, I have challenged. The prayer I have mentioned, not considering from the completion of 10 years.
They are regularized from the year 2006, my lord. They are seeking from date of completion.
But they have mentioned 1/8/2006.
1/8/2006.
They have mentioned in the order, page number in the order. Page number 176 of the petition. Writ appeal ಸಂಖ್ಯೆ 45 2013 ದಿನಾಂಕ 13/1/2013 ರಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ದಿನಾಂಕ 1/8/2006 ರಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಸಕ್ರಮಗೊಳಿಸಿ ಕಾಯಂ ನೌಕರರಿಗೆ ಅನ್ವಯವಾಗುವ ಪೂರ್ಣ ಸೇವಾ ಸೌಲಭ್ಯಗಳನ್ನು ಮಂಜೂರು ಮಾಡಲು ಆದೇಶಿಸಿದೆ.
ಏನ್ ಹೇಳೋದಮ್ಮ?
Therefore, place for similar orders as
ಅಲ್ಲ,
well.
ಆ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದಾಕ್ತೀನಿ. ಈ ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ ಆಕ್ಚುಲಿ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ತಪ್ಪಾಗುತ್ತೆ ಹಂಗೆ. ಇನ್ನೊಂದು ಇಂಡಿಯನ್ ಸೆಂಟೆನ್ಸ್ ಓದ್ತೀನಿ.
Submitted the 2 days after the interim government order.
ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ interim order dated, government order dated so and so was issued ಅಂತ ಇದ್ನಲ್ಲ, ಅಲ್ಲಿಂದ ಓದಿ. ಅದಕ್ಕಿಂತ ಮುಂಚಿನ ಸೆಂಟೆನ್ಸ್.
Representations given by the petitioner seeking regularization of the services after completion of 10 years of service in terms of the directions given by the Honorable Supreme Court in so and so was rejected.
ಅಲ್ಲ, though allowed, though granted, however, the benefit was directed to be given from 1/8/2006, in contravention to the directions issued by this court. In WP number 50876 of 2019, the Senate Council submits that having considered the contentions raised at the hands of the respondent corporation, including the decision of the Honorable Division Bench in writ appeal number 45 of 2013 and connected matters dated 13/11/2013,
Consequently, annexure W was passed by the respondable.
Submits that having considered the contentions raised at the hands of the responding corporation, including the decision of the Honorable Division Bench, the appeal number 45 of 13, dated 13/11/13.
This court directed the respondents to consider regularization of the services of those writ petitioners from the date on which the petitioners completed 10 years of service, in accordance with the directions contained in paragraph number 53 of Uma Devi's case. Stop. Per contra, learned counsel for the respondent, Mysore City Corporation, submits that the impugned order government order dated 11/9/2020 was issued regularizing the services of the petitioners. However, in terms of the directions given by the Honorable Division Bench in writ appeal number 45 of 2013, their services were directed to be regularized from 1/8/2006, and therefore no fault can be found in the action of the respondent authority. Stop. Next paragraph. What is to be noticed is that this court, in its decision in WP number 50876 of 2019 and connected matters, which was rendered on 21st of October 2020, had also taken note of the directions issued by the Honorable Division Bench in writ appeal number 45 of 2013, dated 13/11/2013. So, nevertheless, in terms of the directions given by the Honorable Supreme Court in paragraph number 53 in Uma Devi's case, this court directed the respondent authorities to consider regularization of services of those petitioners from the date on which the petitioners completed 10 years of service. Stop. As rightly pointed out by the learned counsel for the petitioners, the decision of this court has been upheld by the Honorable Division Bench in writ appeal number 629 of 2021, dated 13th of July 2021. While dismissing the appeal preferred by the state government and the state government, the Deputy Commissioner of Mysore and the Directorate of Municipal Administration. Stop. The learned counsel, when the learned counsel for the petitioners submitted that consequent to the directions given by this court, the services of the petitioners in those petitions have been regularized from the date of completion of 10 years, and therefore the same benefit is required to be given to the petitioners here. Full stop. Next paragraph. Consequently, the petitions are allowed. The impugned government order dated 11/9/2020 is quashed only to the extent of the restriction of considering the regularization from 1/8/2006, and the respondent state government is hereby directed that the services of the petitioners herein shall be regularized from the completion of 10 years of service, as was done in the case of the writ petitioners in WP number 50876 of 2019 and connected matters. We'll stop.
W may be quashed and other service benefit may granted. Next W may not be issued by the corporation, stating that the services have been regularized from 1/8/2006 and their pension has to be granted under the new pension scheme. It is totally wrong. W. In 179, my lord, they say that the petitioners entitled for pension, a new pension scheme, page number 180, point number 6.
Consequently, the official memorandum dated 22/10/2020 at annexure W in the matter of fixation of pension also requires to be modified consequent to the date of regularization as directed by this court. Full stop. The respondent state government, the respondent Mysore City Corporation shall await the government order regarding the refixation of the period of regularization and thereafter pass fresh orders in the matter of fixation of the pension. Stop. To that extent, the official memorandum dated 22/10/2020 is also quashed and set aside.
Modified, my lord. To that extent only.
No. This is only regarding fixation of pension.
Pension. Very well, my lord.
So therefore, it has to
Clause
go.
number 6. Very well.
You will have to
well.
await the fresh orders and thereafter refix. Stop. As and when the government order is issued, refixing the period of regularization of the petitioners, the respondent Mysore City Corporation shall reissue the official memorandum refixing the pension of the petitioners, taking into consideration the government orders that would be passed as directed by this court. The entire exercise shall be completed as expeditiously as possible, and at any rate, the government order shall be issued within a period of 2 months from the date of receipt of a certified copy of this order, and thereafter the respondent city corporation of Mysore shall also issue a fresh official memorandum in the matter of fixation of pension, within a period of 2 months from the date of issue of the government order. Full stop. Ordered accordingly. R1 now. Government has first put it. Yes. 32. Huh? Sorry.
Very memo for withdrawal, liberty to file fresh petition. Yes,
Right?
Suspension order.
Allah, they are seeking liberty. Huh? Learned Counsel for the petitioner has filed a memo dated 10/3/2022, seeking leave of this court to withdraw the writ petition with liberty to file a fresh petition, if the respondents initiate disciplinary inquiry proceedings against the petitioner. Full stop. Next paragraph. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn, with liberty as prayed for reserved in favor of the petitioner. Huh?
Matter during internal application serial number 50. For the petitioner's counsel. This case is quite a checkered history because from 2015, several interim orders were passed. Thereafter, certain promotions were granted contrary to the interim orders of the Honorable Court, and the matter went to Supreme Court, and then Supreme Court directed reversion. And then in the meantime, the new C&R rules have been brought into force. So that changes the entire equation. So I'll just take my lords to what happened in the case. IA number 1 of 2020 that is listed today, that was filed by the BBMP members. First case 7472.
Umadevi case.
IA number 1 of 20, IA number 2 of 2020 began. It was filed with the BBMP. There, they have just narrated all the orders that were in force in different petitions. This matter relates to promotions to the cadre of assistant executive engineer and executive engineer in BBMP. The feeder cadres are junior engineers, assistant executive engineer, and then executive engineer. To the earlier for promotion to the post of assistant executive engineer, it was from promotion from junior engineers and assistant engineers in the ratio of 2:1. And from AWEs to executive engineer, the promotion was from AWE to executive engineer. The dispute arose with regard to allegation.
You have who has filed this? IA number 2. Order ಆಗಿದೆಯಾ?
No, no, that order does not reflect. IA they have narrated from day one how many petitions were filed.
When was it filed?
Lords, it was filed on 12/3/2020.
ಹಳೇದು ನೋಡ್ರಿ ಇರ್ಬೇಕು ನೋಡ್ರಿ. ಇದೆಯಾ ಕೊಡಿ ತಗೊಳ್ಳಿ. Yes.
In the context, the issue was with regard to ratio violation, 2:1 from junior engineers, assistant engineers to the cadre of AW post. So, Lords, paragraph number 2, Lords, first petition was filed. May I read, Lords? I submit that Atif Mohammed HB and 14 others from the cadre of assistant engineers filed WP number so and so against BBMP, in which on 4/12/2015, the Honorable High Court passed an order as below. The respondents are restrained from making further promotions from the cadre of junior engineers to the cadre of assistant executive engineers in excess of the quota. I submit that Sri HK Dipesh and others filed WP number so and so from the cadre of assistant engineers against the state and BBMP, in which on 22/12/2015, the Honorable High Court passed an order as below. Emergent notice regarding rule, stay of further promotions from the cadre of junior engineers or assistant executive engineers who have been promoted from the cadre of junior engineers. WP number 58763 of 2015 has been dismissed as withdrawn on 23/10/2018. Then, Lords, I submit that P. Dayanand and others, that is the first petition today, filed WP number 7472 of 2016 from the cadre of junior engineers against the BBMP, in which on 11/12/2016, the Honorable High Court passed an order as below. Respondents are directed not to grant promotions to the cadre of assistant executive engineer in usurpation of the quota sought for by the petitioners. However, this interim order shall not come in the way of the respondents if the case of the petitioner is also being considered for promotion to the quota that they claim to be promoted in terms of the vacancy existing as on today. I submit that in WP number so and so on 30/3/2016, the Honorable Court directed the BBMP to inform to the court whether BBMP had plans to convene DPC meeting for promotions to the post of assistant executive engineer prior to 30/6/2016. I submit that with the backdrop of these three judicial orders dated so and so, the Office of the Administration had expressed its intention to move the issue to the Departmental Promotion Committee. While doing so, it expressed to have an opinion not only from an expert in service matters but also from an advocate, particularly how and in what way the orders of the Honorable Court is to be complied. I submit that Apuraju and Ravi Kumar from the cadre of junior engineers filed WP number so and so against BBMP, in which on 6/10/2016, the Honorable High Court passed an order as below. It is clarified that any promotion made by the respondents to the post of assistant executive engineer shall be strictly subject to the decision of these writ petitions. These cases along with WP number so and so. I submit that on 15/11/2016, the Dean and Deputy Commissioner Admin fixed DPC meeting on 7/11/2016 at 3 p.m. DPC was held on 8/11/2016. The DPC recommended for promotions 42 assistant engineers out of 47 and recommended for promotion of 4 assistant engineers from Hyderabad, Karnataka quota and 1 junior engineer respectively to the post of assistant executive engineers. I submit that in the DPC held on 8/11/2016, the ratio, that is 2:1, has been maintained. Recommendation of DPC dated 8/11/2016 not at all materialized as it was not given effect to. I submit.
2:1 is maintained.
2:1 is for every 3 vacancies. 2 posts should go to assistant engineers.
Correct.
1 post.
The previous paragraph that you read,
Please, my lords.
DPC recommended
42 executive assistant engineers for promotion and recommended promotion of 4 assistant engineers and 1 junior engineers. That is what we were agreed by this at that point. We were agreed by what they had said.
In spite of that, they say
yes,
ratio of 2:1 is maintained.
That is their assertion. Subsequently, therefore, this court stayed. I'll go to the next paragraph. They did not give effect to this. My lords, may kindly note this. Recommendation of DPC dated 8/11/2016 not at all materialized and it was not given effect to. Then I submit that in the above context, the matter was moved before the Honorable High Court. In WP number 7472 connected with so and so, the Honorable High Court, after hearing, passed an order IA number 3 of 16 on 10/11/2016 as below. Presently, the BBMP, without informing the court and without taking this court into confidence, has proceeded to convene a DPC meeting on 7/11/2016. This court does not appreciate such a surreptitious manner of convening a meeting by the BBMP without the remission of this court. In fact, time should have been given by the BBMP to the court to resolve the controversy one way or the other. For the decision of the court would only have helped the BBMP in taking its decisions. Yet for reasons best known to the BBMP, it has convened a DPC meeting without waiting for this court to pronounce its judgment. In Kedena of cases, the Honorable Supreme Court has held that even if there is no stay order granted to the court, but in case the dispute is under adjudication before the court and the parties are supposed to maintain status quo and not to take any action which would unnecessarily complicate the situation. Therefore, this court has expected the BBMP not to convene the DPC meeting till the present controversy is decided by this court. Although convening of DPC is fait accompli, as on today, considering the fact that and needs to decide by this court directs the BBMP not to proceed further with the decision of the DPC till these petitions are decided by this court. I state that by the directions issued by the Honorable Apex Court, V.K. Pavitra versus Union of India, in so and so, this office had to comply by giving promotions to the vacant post in the cadre of assistant executive engineers. I further state that not only in view of the above compulsion, but under the misconception and under a mistaken notion that it may lead to contempt of court in the event of not giving promotions, DPC was held on 2/7/2018, in which the cadre of assistant executive engineer, including 32 persons who had been kept under independent charge under 32 of KCSR, maintaining 2:1 ratio by signing the proceedings on 12/7/2018 and 30/7/2018. I state that being agreed by the recommendations of the DPC and consequential promotion orders, CCC number so and so was filed before this Honorable Court, in which the Honorable Court passed an order on 8/11/2019 that the contempt petitioners have to approach the learned single judge for quashing in case if any further promotions are given, and if it is so advised, the petitioner shall make necessary application before the learned single judge seeking direction or modification of the order. The contempt petitioners, instead of approaching the learned single judge, filed civil appeal number so and so, arising out of SLP number so and so, before the Honorable Supreme Court. After hearing the matter in civil appeal number so and so, the Honorable Apex Court observed on 27/2/2020 as follows. We therefore allow these appeals, set aside the view taken by the High Court, and hold that the exercise undertaken when issuing the aforesaid promotion orders was not correct. We therefore direct as under. The respondent corporation shall within 7 days from today withdraw the concerned promotion orders 12/7/2018 and 30/7/2018 and restore the status quo as was obtaining on the date when the undertaking dated 7/12/2016 was furnished on behalf of the corporation before the High Court. As a result of the withdrawal of the promotion orders as directed herein above, the concerned persons will now be put at the original level that they were occupying before such promotion orders were issued. We, however, direct that no proceeding for recovery of any monetary benefits or emoluments were given to the persons as a result of the promotion order shall be initiated against anyone. Consequently, the contempt proceedings against the contemners shall stand disposed of subject to directions as aforesaid. Needless to say that it shall be open to any party either to request the High Court for expeditious disposal of the pending proceedings or to ask for variation of the interim orders passed by the High Court as aforesaid, but only after the direction as aforesaid is complied. With the aforesaid observations, these appeals are allowed no cause. I state the consequence to the orders passed by the Apex Court. In obedience, this respondent withdrew promotions given to the concerned. Consequent to DPC dated so and so, the abstract showing the number of demotions is as mental. Can you see this note? Executive engineer AWE demoted cadre AE 55 and JE were 10. So in this DPC, that ratio was maintained. It's the next DPC. In all, 78 officers as above have been reverted back to their original positions as per column 3 above. Consequent posting orders in reverted cadre have been issued respectively to them. I state that consequently, 8 posts of EE, 55 posts of AWE, plus 10 posts of AWE, plus 4 posts of AWE under Rule 32 of KCSR, and another 1 post of AWE under Rule 32 of KCSR in all 78 posts in engineering department are now vacant. I state that within 20 days, financial year 2019-20 is coming to an end. The provision made in the budget are to be spent. Several projects undertaken by the corporation are nearing completion. First, thereafter, they request for finally the prayer may kindly be seen. I've just read this for narration. Because therefore, they sought that I pray that this Honorable Court may be pleased to direct this respondent in holding departmental promotion committee and in giving consequential promotions in the larger interest of Palika in the interest of justice and equity. Now, the matter went up to the Supreme Court, then there was reversion of promotions. Now, when this application was filed, this was filed in persons of the Supreme Court observation that we could seek for they could seek for modification or for disposal. When this application was filed in 2020, March 2020. Thereafter, my lords, there was for 3 months the applications did not were not put up. But in March 2020 itself, there was a subsequent development where the new C&R rules, my lords, came into force. Whereby, my lords, the cadre, there was bifurcation of the cadres and slightly there was a different promotional avenue that was given. My lords, I just, my lords, there is the new C&R rules, my lords. The new C&R rules with
I don't think the other matters are going to reach. Please not wait. Yes.
Because this was a new C&R rules that was brought into, it was notified on 16/3/2020. Now, my lords, I'm just, we had passed on a tabulated statement showing the comparison, lords, of the old, as per the old rules and as per this rules. I'm just passing it on to the memo. There is a statement that I had already passed on, but for convenience.
Of 21, my lord. Serial number 30. That may please be postponed for a week, my lord.
Yes. So let's kindly see the memo, page 1 of the memo, lords. There is one statement in landscape, page 1. I'm sorry, lords, page 2. Lords, I've just given a comparison, lords, of the earlier, as per the earlier rules, and on the right side, lords, it's the new 2020 rules, lords. Lords, may kindly see, as per on the left hand side columns, lords, the earlier method of recruitment, junior engineers, my lords, get it. Junior engineers, there were 87 posts, lords, and the number of posts, lords, was 50% lords of filling of direct recruitment and promotion. So far as junior engineer post is concerned, lords. Then, my lords, get it. On below that, my lords, there is assistant engineer post. That is, my lords, 50% by direct recruitment, 25% by direct recruitment or transfer of JE, and 75% by deputation. Now, my lords, below that, assistant executive engineer. That is the main thing, lords. Assistant executive engineer, lords, there were total 118 posts available before this amendment, before this new rules came into force. 25% of the posts were to be filled up by deputation from PWD and 75% by promotion. And lords, among, insofar as promotion is concerned, it was from AE, JE cadres in the ratio of 2:1. So if we take it as 2:1, 75% posts become 88 posts and 59 posts for AEs and 29 posts for JEs. That is how it works out. Huh? Lords, assistant executive, left side assistant, my lords have assistant executive engineer. Then 25% is deputation. 25% deputation from PWD, and there is one.
It is other way. 25% direct recruitment or transfer from JE.
No, my lords are in, that is assistant engineer. I'm an assistant executive engineer. Assistant executive engineer, 25% is deputation from PWD and 75% is promotion. Out of that, on the right side, lords, it is to be filled up from amongst assistant engineers and junior engineers in the ratio of 2:1. Now, lords, may kindly see on the right side column with regard to the new rules. Now, lords, junior engineers, we are not concerned much. Insofar as assistant engineer, my lord, there was two separate, they have bifurcated the cadre into division 1 and division 2. Division 1 and division 2, what they have done, my lord, says, insofar as division 2 is concerned, assistant engineer new post has been created called assistant engineer division 2, where 100% is to be filled up by promotion from junior engineers. Earlier, junior engineers could be directly promoted as AWEs. Now, junior engineers will first go to assistant engineer division 2. And above that, my lords, there is assistant executive engineer division assistant engineer division 1, my lords, which is also now a separate cadre. It is 50% by direct recruitment, 30% by transfer from assistant engineer, 20% by deputation.
The petitioners are?
We were junior engineers. Now we have been promoted to assistant engineer division 2. We are aspiring for promotion to assistant engineer, executive engineer division 2, my lords. Now after that, my lords, now the issue is with regard to assistant executive engineer division 1 and 2. Assistant executive engineer, my lords, they are divided into two separate subcadres, named it as division 1 and division 2. Now, my lords, for division 2, it is exclusive promotion from assistant engineer division 2 to assistant executive engineer division 2. I will call it AE1 and AE2, my lords, and AWE1 and AWE2. Now, insofar as AWE1 is concerned, it is 50%, 75% promotion from AE1 and 25% deputation. So now, my lords, by virtue of this new C&R rules, what happened was, earlier there was the 2:1 ratio was there. The entire dispute was with regard to the 2:1. Now, by virtue of this,
resolve
now this is the new thing. Yes. Now, separately, these rules, apart from these cadres, these rules were separately independently challenged that we are not concerned with, my lords. But the problem, what happened, my lords, was when these rules came into force, totally there were, if my lords see AWE posts, there were 118 posts that were available. When these new rules came into force, in the new rules, my lords, they have reduced the number of posts to 79, 67 plus 12 madi. Now, therefore, the controversy was at that point in time. If my lords see, we were claiming, my lords, that we are entitled to promotion to 12 posts of AWE2. And my lords, that AWE1, they will get 75 posts, they will get 50 posts, and the remaining posts for 17 posts. That was a controversy, my lords. There is a subsequent order that was passed by this honorable court on that. I'll take my lords to that. Now, what happened was, because of the reduction of posts, now we filed this application, and it was their contention that the posts are not being manned. They need to make promotions because in the interest of the administration. So therefore, this one
actually, if you see,
please,
left-hand column.
Yes,
although there were 118 posts,
yes,
what was available for AEs and JEs,
yes,
is only 75%.
Please, only 75. Only 75.
Okay, 75.
Yes, yes.
Otherly, if you see, it will be 88 posts.
88 posts. That's it. 88. Now, including deputation, they made it 79.
So earlier, what was available for assistant engineers was 59 posts.
Yes, ma'am.
And JE is 29 posts.
Yes, ma'am.
But
now, when at this stage, what had happened was there was a dispute. BBMP had taken up a contention. If my lords may kindly see now the rule AWE, because this is our interpretation that we had said this is the number of posts that are available. Now, kindly see, my lords, the rule, my lords, I just passed on. The new C&R rules, page number 24 only. I'll just read, my lords, the relevant. Page number 24. Lords, assistant executive engineer within brackets civil. Now, kindly see they give sub-Roman number 1. Assistant executive engineer civil division 1. And below that, lords, assistant executive engineer civil division 2. These are the two divisions. Now, let's kindly see on the middle row, middle column. Assistant Executive Engineer Civil Division 1 in bold letters. Within that, serial number 1, 75% by promotion from the cadre of Assistant Engineer Civil Division 1. Even note, the cadre strength of Assistant Engineer Executive Engineer Division 1 for promotion shall be 85% of the combined cadre strength of Assistant Engineer Division 1 and Assistant Executive Engineer Division 2. Demand for filling up of additional posts of Assistant Executive Engineers may be allocated between Assistant Executive Engineer Division 1 and Assistant Executive Engineer Division 2 in the ratio of 5:1. Then serial number 2, 25% by deputation of Assistant Executive Engineer Civil from the Karnataka Public Works, Sports and Inland Waterway Transport Department. Then Assistant Executive Engineer Civil Division 2 by promotion from the cadre of Assistant Engineer Division 2 Note that the cadre strength of Assistant Executive Engineer Division 2 shall be 15% of the combined cadre strength of Assistant Executive Engineer Division 1 and Assistant Executive Engineer Division 2. Now, if my lords may see in the third column, it is 79 posts put in. 79 posts. Lords, at this stage, my lords, what had happened when this application was listed, my lords, after the new C&R rules came into force, the dispute was with regard to. Now, as per this, what we were saying is out of 79 posts, 85% cadre strength is 85% goes to Division 1, 15% goes to Division 2. Out of Division 1, they have carved out 25% quota for deputation. That was our interpretation. That is what I had stated. But BBMP's interpretation at that point of time was out of 75% posts, 25% deputation we are taking it out. The remaining posts will be divided 85 into 85% and 15%. So their interpretation, according to us, we were at that point of time getting, there would be 12 posts of AWE2. But according to the BBMP, their calculation was 9 posts of AWE2. So there was a difference of 3 posts. In that connection, this honorable court considered their application and our objections and these new rules, and passed an order in the first case on 28/11 on 25th of February 2021. My lords may kindly see the order. 25th of February 2021. But I'll just read the order first. Shri so and so learned senior counsel for so and so appears for the petitioners in WP number 7472 connected with so and so, who are all petitioners in WP number 1936 of 2021. Shri so and so learned senior counsel for learned counsels so and so, and learned counsel on record for other respondents heard. The learned counsel for the other respondents support the submissions by the learned counsels. The preface to this order is that there is unanimity among the learned senior counsel and learned counsels for the parties as regards the following. The repetition in WP number 1936 of 2021 could be tagged along with WP number 7472 of 2016 and connected matters. After the orders of the Honorable Supreme Court in Civil Appeal number so and so on 27/2/2020, the state government has notified the Growth Bengaluru Mahanagar Palike General Cadre and Recruitment of Officers and Employees Rules 2020, for short Rules 2020, and without prejudice to rival submissions on merits, promotions to Assistant Executive Engineer Civil Division 1 could be considered by the BBMP if the earlier orders of this court on 10/11/2016, WP number 7472 of 2016, and connected matters is modified. This court on 10/11/2016 directed the BBMP not to proceed further with the decision of the DTC till the petitions are decided by this court. With the notification of the rules 2020, the post of Assistant Executive Engineer Civil will comprise of 3 categories, that is Assistant Executive Engineer Civil Division 1, Assistant Executive Engineer Division 2, and Assistant Engineer Executive Engineer by deputation. Then there is a footnote 1. Kindly see the footnote at that stage. At this stage, she so and so intercedes to assert that in so far as his claims to aspire for promotion to Assistant Executive Engineer Civil Division 2, the deputation will have to be from out of the Assistant Executive Engineer Civil Division 1 and cannot be a separate category. That was the submission that was noted. According to the rules 2020, the petitioners in WP number so and so, who are also petitioners in so and so, could aspire for promotion only to the post of Assistant Executive Engineer Civil Division 2, and the Assistant Engineer Division 1 will be entitled for promotion to the post of Assistant Executive Engineer Civil Division 1. The controversy, apart from all other rival submissions, is about the number of posts that will have to be earmarked for Assistant Executive Engineer Civil Division 1. But for this controversy, promotions could be granted to the post of Assistant Executive Engineer Civil Division 1 from the cadre now called Assistant Engineer Division 1. According to the petitioners, WP number 7472 of 2016 connected with so and so, which has the BBMP which has filed its affidavit today, in reiteration of its submissions, should earmark 3 additional posts for promotion as Assistant Executive Engineer Civil Division 2. The BBMP has erred in stating before this court that only 9 posts have to be reserved for Assistant Engineer Executive Engineer Civil Division 2, when on a true interpretation of rules 2020, it should be 12 posts. In the light of these unanimous submissions, and because the promotions to the officers officiating as Assistant Executive Division 1 to the post of Assistant Executive Engineer Civil Division 1 could be made, excluding 3 posts without contest in that regard, the following interim order is made. Insofar as the 3 posts of Assistant Executive Engineer Civil Division 1 will have to be filled up after the rival submissions are considered by this court. Hence the following. The order dated 10/11/2016, WP number so and so, and connected matters is modified, observing that the BBMP shall be at liberty to grant promotions to the post of Assistant Executive Engineer Civil Division 1 from the cadre of Assistant Engineer Division 1, excluding 3 posts which have to be filled up subject to further orders in these petitions. The office is directed to tag WP number so and so and so and so and other connected matters. C. It would be open to the petitioners who aspire for promotion to the post of Assistant Executive Engineer Civil Division 2, that is as follows, to make an application to the Commissioner BBMP for consideration of their case, and if such representation is made, the Commissioner BBMP could consider the same in accordance with law without prejudice to any of its defense. The petitions are urgent to be called after 3 weeks and the parties are at liberty to complete their pleadings. Now, my lords, this order was clear according to us. 9 posts, my lords, was for Division 2. Remaining posts was for them, 3 posts was in dispute. But my lords, what happened after this, according to us, by misinterpreting this order, excluding 3 posts, they wanted to fill up all posts from as AWE Division 1, including the 9 posts. Therefore, we filed an application for clarification. That order is dated 22nd of April 2021. Not get it. 22nd April. Order on IA number 1 that which we had filed. This court on 25/2/2021, recording certain unanimous submissions as well as the controversy interested parties, modified the interim order dated 10/11/2016 in WP number 7472 of 2016 with liberty to BBMP to grant promotions to the post of Assistant Executive Engineer Civil Division 1 from the cadre of Assistant Engineer Division 1, excluding 3 posts, observing that these posts will have to be filled subject to further orders in these writ petitions. The controversy, insofar as the present application for modification of the order dated 25/2/2021 is regards the number of posts for Assistant Executive Engineer Civil Division 1 and Assistant Executive Engineer Civil Division 2 in the combined cadre of Assistant Executive Engineer Civil. The petitioners in WP number 1936 of 2021, also petitioners in other connected petitions, disputed the affidavit dated 24/2/2021 by the Deputy Commissioner, Administration BBMP, stating amongst others that 12 posts in the combined cadre of Assistant Executive Engineers will have to be filled up from the feeder cadre of Assistant Engineers Division 2 and not 9 posts as stated in para 4 of such affidavit. The petitioners have filed the present application for modification of the order dated 25/2/2021, stating that because the court in the operative portion of the order dated 25/2/2021 did not mention that 9 posts as there was no dispute in this regard, in the combined cadre of Assistant Executive Engineer Civil should not be filled up. The BBMP is presently resolved to keep only 3 posts for the combined cadre of Assistant Executive Engineer Civil for the feeder cadre of Assistant Engineers Division 2. Heard the learned senior counsel so and so for BBMP, who is supported by so and so and so appears to the petitioners. The controversy, apart from the other grounds urged, revolves around the interpretation of the entry rule at serial number 11 for the engineering department in the recent BBMP cadre and recruitment of officers and employees rules 2020. The relevant entry part of this entry at serial number 11 reads as under. My lords have seen it, the same entry. My lords, she so and so submits that the proper reading of this entry rule would entitle those who are working as Assistant Engineers Division 2 to only 5 posts. However, if such interpretation reading is accepted at this stage, there would be an expression of opinion on merits and would also amount to permitting the BBMP to resile from its stand. This court on 25/2/2021 modified the interim order prevailing then solely because it was unanimously submitted by all the learned counsel that the promotion could be given to those who would be entitled without any dispute. This court has not examined the merits of the rival submissions, including the submissions on the ratio to be maintained inter se Assistant Engineer Division 1 and Assistant Engineers Division 2 to the combined cadre of Assistant Executive Engineer Civil. The controversy was only as regards 3 posts. It must be observed here that because there was no dispute that 9 posts could go to Assistant Engineer Division 2, but subject to other rival submissions, this court, considering the submissions by the learned counsel for the petitioners, had given them the liberty to file applications to the commissioner for consideration of the case to be promoted to 9 posts, which are undisputed at that point in time, and 3 posts which are disputed even then, observing that any such consideration shall be without prejudice to the defense of the BBMP. Therefore, there cannot be any promotions to 12 posts of Assistant Executive Engineer Civil without a decision of the rival contentions. In the opposite circumstances, this court is of the considered view that the order dated 25 to 2021 should be clarified to say that promotions to 12 posts of Assistant Executive Engineer Civil cannot be granted, and the embargo in terms of the earlier orders would continue. However, it would be open to the BBMP and other respondents to seek vacation of the order 25 to 2021, which is modified now, or final disposal of the petitions on merits. So, just to protect our interest, court also expressed after noticing that don't fill up 12 posts of AWE posts. At that point in time, we were claiming promotions to the cadre of Assistant Engineer Division 2 from junior engineers. Now, thereafter, what happened was
the other AWE Civil Division 1 is being filled up, is it?
They filled it up. Division 1, the promotions were granted on the basis of one DPC that was held. What happened on 25?
Why did you not take the benefit of filling up the 9 posts?
I have given a representation for
the dispute is only in respect of 3 posts.
Yes,
why did you not take permission to fill up 9 posts?
I sought for promotion to the 9 posts. My proposal was sent by the BBMP to the state government. Now the state government has misread this order, and now it has returned back the proposal stating that 12 posts should not be filled up. Therefore, my lords, I have filed these applications. That is.
Yenanta?
My lords, kindly see that memo, my lords.
Allah, they were only seeking clarification. It was very clear. No. The dispute is only regarding 3 posts. When benefit is given to fill up the post cadre from AE cadre, similar benefit they also should have taken.
I'll just complete.
Anyway,
I'll just complete.
You are for BBMP, is it? You are for BBMP. You are for the coming from. Are you from JE category or AE? AE. Therefore, to resolve this controversy, they have rightly amended the rules. They have rightly amended that one, and it is now very clear. I do not know why this controversy regarding 3 posts have arisen.
What are the vacancies available on that? They claim that 50%, 15% and 85% they calculated in a different manner.
Amana, let us see. If the controversy is only that much, we will resolve it.
That is all.
I don't think it is.
There are 2 subsequent developments. I'll just finish that. There are 2 subsequent developments. What had happened? Now,
Allah, ivaga agala. 5 o'clock. I've got it.
Please, I'll continue.
We will do it. We will do it.
Please. Tomorrow,
I don't know. ಎಷ್ಟಿದ್ದಾರೆ ಮ್ಯಾಟ್ಗಳು ನಾಳೆ ಮಧ್ಯಾಹ್ನ 2:30 ಹಾಕೋಬೋದ ಇದು ನಾಳೆ 2:30 ಯಾವ್ದಾರು ಇದೆಯಾ? ಆಯ್ತು. Third, Learned Senior Counsel, Sri Rubin Jacob, for the petitioners. CWC number 7472 of 2016. Read this matter on 14th of March 2022 at 2:30.
My lord, serial number 30, my lord.
BBMP. He is due for promotion. So same orders. One copy today. Similar orders.
Serial number 27. Serial number 27, my lords, appointment has been, the petitioner has been removed from service, my lord, on the basis of maskers, BTech maskers, my lords, from Karnataka Open University, my lord. Let us because yes, that will continue in service, my lord.
Next matters, next week only it has to come. It has to come next week only. All matters that have not reached now will come up next week.
Entry matter.
So it should be on 17th of March. 17th of March. Yes.
Serial number 30, my lord.
No, our 2011 matter and I given that date. Otherwise, we'll see.
Entry matters.
40%. Ogilva. Serial number 30. Serial number 13. 14% ಅಂತ ಹಾಕಿಲ್ವಲ್ಲ. Respond number 4. What is it? You have not gone before the committee? You have not gone before the committee? You have gone before the committee, but no certificate is given. But there is no certificate granted still. You have been given the certificate, is it? Yeah. Respond number 4. Respond number 4. Respond number 4. Srimati Kanika Chakrabarti. The name of so and so shall be shown in the cause list as party in person. ಆಯ್ತಲ್ರಿ ಇವಾಗ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಇನ್ನೇನು. Serial number 30 release this matter on 17th of March.
Serial number 43 minutes because it is regarding repatriation minutes. Term is going to end this April minutes.
17th.
17th.
ಆಯ್ತು 17th.
ಅಲ್ಲ
ಯಾವುದು ಇವ್ರದ
repatriation minutes because term is going to end. Respondent they are not entitled towards the post mallet.
17th of March.
Please, serial number 46. 46 is the same order. Annexer what we have to do. Annexer A and B. First one. Annexer A and B. First one. So A and B is connected matters on the
ಈಗ 26 ಇದೆ. ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಕೊಡ್ತೀನಿ ಕಾಮನ್ ಇಲ್ಲ ಅಲ್ಲ ಕೊಡ್ತೀನಿ ಸಾಹೇಬ್ರ ಜೊತೆನೆ
ನೆಕ್ಸ್ಟ್ ಇಯರ್ A and B.
ನಮ್ದ್ರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಇಯರ್
Next year A and B.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಹೇಳಿದಾರೆ ನೋಡಿ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಹೇಳಿಲ್ವಾ ಕುಡಿಲಿ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸರ್, ಇಲ್ಲಿ ನೋಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸ್ಪ್ರೇಟ್ ಫಾರ್ ಅಂತ ಬರ್ದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ
ಸ್ಪ್ರೇಡ್ ಫಾರ್ ಅಂತ ನೋಡಿ ಕೆಳಗೆ ಮಾಡಿ ಹಂಗೆ ಮಾಡಿ
ಮೇಡಮ್ ಏನಿಲ್ಲ, ಕನ್ಸಿಡರ್ ಫಾರ್ ನೆಕ್ಸ್ಟ್ ಪ್ರಮೋಷನ್ ಅಂತ ಬರ್ಬೇಕಷ್ಟೇ, ಎಲ್ಲಾದ್ರಲ್ಲೂ ಇದೆ, ಕನ್ಫ್ಯೂಸ್ ಆಗ್ಬಾರ್ದು. ಫಾರ್ ದಿ ನೆಕ್ಸ್ಟ್ ಕೇಡ್ ಅಲ್ಲಲ್ಲ ಸೇಮ್ ಮಾಡ್ರಿ ಏನಿದೆಯೋ ಅದು ಅದ್ರಲ್ಲಿ ಏನಿದೆಯೋ ಅದು ಇಲ್ಲ 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 ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅದು
27 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಸಾಹೇಬ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರಲಿ ಅಂತ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಸರ್.
ಕರೆಕ್ಟೆಡ್ ಇದೆ ಅದು ಇಲ್ಲ, ಅದು ಏನಿದ್ರು ಫಸ್ಟ್ ಟೈಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಬಂದಿತ್ತು. ಏನಂತ ಕಾಪಿ BBMP ಫಸ್ಟ್ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲಣ್ಣ ಸರ್ವ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು. ಅಲ್ಲ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು ಅಷ್ಟೇ. ಸರ್ವ್ ಮಾಡಿ ಅದು ಸೀನಿಯರ್ 4490 ಬಂತು 22 ಸೀನಿಯರ್ಟಿ ಇದಿತ್ತು. ಅದಕ್ಕೆ ವರ್ಕ್ ಮಾಡಿ ಅದು ಕ್ಲಬ್ ಮಾಡಿ ಕಳಿಸಿದ್ದೀರಾ? ಅದು ಫಸ್ಟ್ ನೀವು ಹೇಳ್ದಂಗೆ ಏನಂತ ಆಫೀಸ್ ಶಿಕ್ಷಣ ಬಂದಿದ್ದು, ಆಫೀಸ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ BBMPಗೆ ಅಂತ. ಸಾಹೇಬ್ರು ಏನ್ ಮಾಡಿದ್ರು, ಇನ್ನೊಬ್ಬರಿಗೆ ಸರ್ವ್ ಮಾಡಕ್ ಅದ್ಯಾರು ಯಾರ್ಯಾರಿಗೆ ಹೇಳಿದ್ರು ಏನೋ ಹೇಳಿದ್ರದ್ದು ಅವ್ನು ಸರ್ವ್ ಮಾಡ್ದ. ಅದ ಬಂದಾಗ ಆಫೀಸ್ ಆಫ್ ಒಂದು ಒಂದು ಇನ್ನೊಂದು ಬರಲೇ ಇಲ್ಲ.
ಕೊಡೋದು ಬೇಡ ಅಂತ ಹೇಳಿ ಅವ್ರಿಗೆ. ನೋಟಿಸ್ ಆಗಿದೆ ಅಂತ.
Paper 45.
ಕಷ್ಟ ಇದ್ರೆ ತಿರ್ಗಾ ನಾವು ಹಾಕಿ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ ಹೆಂಗಿದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ. ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡೋದು ಯಾವತ್ತೇ ಮಾಡಿರೋಲ್ಲ. ಈಗ ನೋಟಿಸ್ ಮಾಡ್ತಾರಲ್ಲ, ಏನಿಲ್ಲ, ನೀವು 44 ನೀವು ಮಾಡಿರಪ್ಪ, 4487 ಮೂವ್ ಮಾಡಿರೋದು. ಈ 4483 ನೀವು ಕನೆಕ್ಟ್ ನೀವು ಮಾಡ್ಬಿಟ್ರೆ ಕನೆಕ್ಟರ್ ಆಡ್ ಮಾಡ್ಬಿಡ್ತೀರಾ?
Paper 45. Entry ಮಾಡ್ರೋ next. ಡೇಟ್ ಏನು ಕೊಟ್ಟಿದ್ದಾರಾ? ಇದು ಮಾಡೋ ಇದೆಯಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು. ನೆಕ್ಸ್ಟ್ ಮಂಗಳವಾರ ಡೇಟ್ ಕೊಡ್ಬೋದಾ? ಥ್ಯಾಂಕ್ ಯು.
17 ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, 4800 ಆರ್ಡರ್ ಬಂದಿದೆ. 4800 ಇವಾಗ ಡೇಟ್ ಅವ್ರಿಗೂ ಕಳಿಸ್ಬೇಕು.
ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ 40% ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ. ಇವಾಗ ನೋಡಿ, ಅವರು ಫೈಲ್ ಮಾಡಿರ್ತಾರಲ್ಲ, ಈ ಫೈಲ್ ಮಾಡಿದ್ರೆ ನಾವು ಕೊಡ್ತೀವಿ. 40% ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಸಿ ಅಪ್ಲಿಕೇಶನ್ ಕಂಪ್ಲೀಟ್ ಸಿಗ್ನೇಚರ್ ಆಗಿಲ್ಲ. ಆಯ್ತಾ? ಆನ್ಲೈನ್ ಹಾಕಿದ್ದೀರಾ, ಕಮಿಟಿ ಮುಂದೆ ನೋಡ್ಕೊಂಡು ಸಿಗ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ
ಗೊತ್ತಾಗುತ್ತೇನಾ? ಸುರೇಶ ಏನಿದೆ ನಿಮಗೆ ಕೆಲಸ ಇಲ್ಲ ನಿಮಗೆ?